In this lecture, let us discuss Union Legislature. And here we will discuss Rajya Sabha, Lok Sabha. We will discuss the qualifications required for someone to contest elections to Lok Sabha and Rajya Sabha. What are the disqualifications as well? What is the role of Rajya Sabha? What is the role of Lok Sabha? What are the various offices of Lok Sabha and Rajya Sabha? We will also be looking at what is Office of Profit. We will be looking at the sessions of the Indian Parliament. What is this monsoon session, budget session, winter session? We will be looking at the powers, privileges, and immunities of the members of the Parliament. We will also be looking at how the budget is passed. We will also be looking at what is a money bill, what is a financial bill, what is an ordinary bill. All this and much more in this lecture. So let's get started. And first up, let's look at Article 79 of the Constitution. Article 79 says there shall be a Parliament for the Union, which means Union Legislature, and this Parliament shall consist of President, Rajya Sabha, and Lok Sabha. That means President is an integral part of Parliament, which is the legislature, and President is an integral part of the executive as well. Because we follow the British parliamentary system, and in Britain, the head of the state, which is the Queen or the King, is both part of the executive as well as the legislature, and same system is what we follow in India as well. So Article 79 talks about Parliament, which is the Union Legislature. Union Legislature has three organs: President, Rajya Sabha, and Lok Sabha. When we discuss the office of President, we discuss some of the powers of the President as well. But I told you, when it comes to legislative powers, when it comes to financial powers, when it comes to judicial powers, we will not discuss in the Union Executive, we will discuss in the Union Legislature. So in Union Legislature, we will discuss the legislative and the financial powers of the President, and then we will jump to the state machinery, where we will talk about the office of Governor. In that office of Governor, we will discuss the judicial powers of the President, because the pardoning powers of the President are more or less similar to the pardoning powers of the Governor of a state, with some differences, and we shall discuss all of them in the state machinery. So Union Legislature, Parliament consists of President, Rajya Sabha, and Lok Sabha. But when we look at Parliament, we say Parliament performs multiple functions. And which are these multiple functions? Number one, Indian Parliament is the supreme lawmaking body for the centre. That means when we look at the distribution of powers, this is something that we have discussed very briefly. In distribution of powers, we have something called union list, state list, concurrent list. That means all those subjects, all those items that are mentioned in the union list. Who has the power to make laws on all these subjects? Union Legislature, which is the Parliament. That means the first major function of the Parliament is lawmaking. That's what Union Legislature term signifies. What is a legislature? A body which enacts laws, which makes laws. And Indian Parliament, the first and the foremost and a very important function of the Parliament is lawmaking. On which items, on which subjects does the Indian Parliament have the power to make laws? All those items mentioned in the union list. That means when it comes to banking, insurance, foreign affairs, communication, defense, citizenship, extradition, on all these subjects, Union Legislature, the Parliament has the power to make law. That means the first important function of the Parliament is lawmaking. Similarly, items mentioned in the concurrent list, Indian Parliament also has the power to make law on any item mentioned in the concurrent list as well. For example, marriage, for example, divorce, for example, civil procedure, criminal procedure, education for that matter. On all these items, Indian Parliament has the power to make laws. Which means the first main function performed by the Indian Parliament is lawmaking. Second, we also derive the executive from the Parliament. What do we mean by that? Parliamentary democracy is Council of Ministers are accountable to the Lok Sabha. Or should we say parliamentary democracy is that the government is accountable to the Parliament? And when we look at the parliamentary form of democracy, something which we have borrowed from the Britain model, we say that executive is also part of the legislature. That means there is no strict separation of powers between the executive and the legislature when it comes to a parliamentary democracy. Because in parliamentary democracy, who all are part of the executive? We have president, we have prime minister, we have council of ministers. All these ministers and the prime minister, they are drawn from the legislature. That means other important role or function which is performed by the Indian Parliament is that it supplies us with the executive. The executive is drawn from the legislature. That's another important role played by the Indian Parliament. Third important function of the Parliament is its constituent power or constituent function. 1946, cabinet mission was sent to India, and it is this cabinet mission which promised us a constituent assembly. This constituent assembly, which is a body which was tasked with writing the constitution for India, drafting the constitution for India. This constituent assembly met for the first time on 9th of December 1946, and for the next couple of years, they discussed, debated, and deliberated on the shape and the contours of our constitution. And this constitution we adopted on 26th November 1949, and this constitution entered into force on 26th January 1950. But what happened to the constituent assembly, which was a body tasked with writing the constitution? This constituent assembly was dissolved. Now, after 1950, do we need to amend the constitution or not? Because Pandit Nehru said constitution has to be a living document. Constitution is basically a document of people's faith and the aspirations. Aspirations may change, sentiments may change, and all these legitimate aspirations must be capable of realization. That means we need to amend the constitution. When we have to amend the constitution, for that, do we need to set up another different constituent assembly? No. Constituent assembly was dissolved, and now that power to amend the constitution is also given to the Parliament. That is another important role which Parliament performs is its constituent role, which is that it is a body which is used to amend the constitution as well. That is function number 3 of Indian Parliament. Function number 4, Indian Parliament is the source of authentic information. For example, you need authentic information on, let's say, the migrants who left because of COVID-19 pandemic, or we need authentic information of what is happening along the line of actual control between India and China. Or for that matter, we need authentic information of what is happening on the economic front, what is happening on the domestic front, what is happening to our internal security. For that, we can't turn on our TV sets and look at the nation wants to know kind of explanation. The authentic information has to be provided on the floor of the Indian Parliament, and that is how legislators, they ask questions to the ministers. Question hour, 0 hour, short duration questions. It is through these debates and discussions and questions and answers in our Parliament that we get the authentic information on anything that we need to know. Which means another role which is performed by the Parliament is educative role. It educates the masses because of these discussions and debates, because of these questions and answer sessions. It is through these discussions and questions and answers that people of this country get the authentic information of what is happening in India. That is another role played by the Parliament is that it is the source of authentic information. There is another role, and that is the financial role. And what is the financial role played by the Indian Parliament? We will discuss in great detail this slightly later, but very briefly here. We have something called Consolidated Fund of India. Almost the entire money that is raised by the Government of India that gets deposited into this Consolidated Fund of India. But who is the custodian of Consolidated Fund of India? Parliament. When we say who is the custodian of Consolidated Fund of India, what do we mean by that? Not even a single penny can be withdrawn from Consolidated Fund of India unless and until Parliament approves it. That means withdrawal of money from Consolidated Fund of India has to be approved by the Indian Parliament. Budget has to be passed in the Indian Parliament. Money bills have to be passed in the Indian Parliament. Financial bills have to be passed in the Indian Parliament. That means another role that is performed by the Indian Parliament is the financial role that is performed by the Indian Parliament. So when we look at Article 79, it says that Union Legislature, which is the Parliament, consists of President, Rajya Sabha, Lok Sabha. But when we look at Parliament, we say Parliament performs multiple functions, multiple roles are played by the Indian Parliament. Which are these multiple roles played by the Indian Parliament? Number 1, it's the supreme lawmaking body at the central level, at the union level. Number two, it supplies us with the executive. Number three, it has its constituent power as well. That means Indian Parliament is empowered to amend the constitution. Yes, this power is not absolute. It is subject to restrictions. And one such restriction that is imposed is the doctrine of basic structure. That means yes, Parliament has the power to amend the constitution, but don't you dare touch the basic structure of Indian constitution. And who has defined this basic structure? Supreme Court. That means constituent power, which is the power of the Parliament to amend the constitution. Yes, it has the power to amend the constitution, but it is not unlimited power. There is a restriction. Don't touch the basic structure. And that's why we say Parliament also is not sovereign. Indian Parliament is not sovereign in the sense that any law which is passed by the Indian Parliament, there will be judicial review as well. And when Supreme Court conducts the judicial review on any law passed by the Parliament, which makes Indian Parliament not a sovereign body, but British Parliament is a sovereign body. And this is something that we've discussed in the past as well. They have an unwritten constitution. And in an unwritten constitution, it is the Parliament which is supreme, not the constitution. And that is what D. Lord May also said. D. Lord May said British Parliament can do anything except convert a man into a woman and a woman into a man. And these are the various roles and functions performed by the Indian Parliament. One quick point here, there's another important role which is played by Indian Parliament. And that is to keep the executive under check. And how is the executive kept under check? Through budget, through debates, through discussions, through question hour, through zero hour. Let's say, for example, in Lok Sabha, there are various kinds of motions that can be passed, which we will discuss in great detail towards the end of this chapter. But motions such as confidence motion, no confidence motion, adjournment motion, and it is through these tools that Indian Parliament keeps a check on the executive, or legislature keeps a check on executive. But when we say we are a parliamentary democracy, ours is a parliamentary form of government. And in a parliamentary form of government, Council of Ministers are accountable to Lok Sabha. That means Council of Ministers, headed by the Prime Minister, they shall remain in power, they shall remain in office as long as they enjoy their confidence, they enjoy the majority in Lok Sabha. The moment they lose majority in Lok Sabha, they have no other option but to resign. That means the Council of Ministers is collectively accountable to, responsible to the lower house of the Indian Parliament, which is Lok Sabha. So this was a brief introduction about Parliament and the multifarious roles, functions performed by the Indian Parliament. Now we will talk about Rajya Sabha first, then we will look at Lok Sabha, and then we will club the two together, and we will look at various other aspects of Union legislature.
So let's get started with Rajya Sabha. Rajya Sabha, or the upper house of Indian Parliament.
We say Rajya Sabha is the second chamber of Indian Parliament. What do we mean by second chamber of Indian Parliament? We'll discuss in state machinery that there are some states in India which have a bicameral legislature. What do we mean by bicameral legislature? Two houses of state legislature. For example, Andhra Pradesh, Telangana, Maharashtra, Bihar, Uttar Pradesh, Karnataka. Their legislatures are bicameral. That means they have legislative assembly, which is the lower house of state legislature. They have the legislative council as well, which is the upper house of the state legislature. That means there are 6 states in India which have bicameral legislature. At the central level, we have a bicameral legislature. That means the lower house of the Indian Parliament is Lok Sabha, or House of the People, as it is called. And the upper house of Indian Parliament is Council of States. And this Council of States has a Hindi name, and that Hindi name is Rajya Sabha. But we say Rajya Sabha is the second chamber of Indian Parliament. And when we say second chamber, that means it has an equally important role to play in Indian Parliament. But when we look at legislative councils, we call legislative councils secondary chamber of state legislature. Why secondary? Because they have an inferior role. When we compare the role of a legislative council with the legislative assembly, the role of the legislative council is very inferior. That is why we call legislative council a secondary chamber of state legislature. But Rajya Sabha has an equally important role to play with respect to Lok Sabha. That is why we call it the second chamber of Indian Parliament, not the secondary chamber. First, we will look at what is the composition of Rajya Sabha. When we look at the composition of Rajya Sabha, then we will look at how are these MPs to Rajya Sabha elected. Then we will look at what is the role played by Rajya Sabha, what are the special powers available to Rajya Sabha. Those special powers are not available to Lok Sabha. We will also look at the relevance of Rajya Sabha in today's polity, in today's political culture and environment. When we look at Rajya Sabha, the maximum strength of Rajya Sabha is 250. What is the maximum strength of Rajya Sabha? 250. Out of 250, 238 are to be elected and 12 people are nominated. What are we talking about? Rajya Sabha, which is the upper house of Indian Parliament, Indian Union Legislature. It's also the second chamber of Indian Parliament, not the secondary chamber. But what is the composition of Rajya Sabha? 250 is the maximum strength of Rajya Sabha. Out of 250, 238 are to be elected and remaining 12 are nominated. Who nominates these 12 MPs? President. From which areas? From the fields of art, literature, science, social service. That means 12 MPs are nominated by the President to Rajya Sabha from the fields of art, literature, science, social service. Few quick points here. Number one, it is not the personal decision of the President of India. These names, these 12 MPs, they are nominated by the President, but basically on the advice of the Prime Minister, because President does not have an individual power in nominating these 12 MPs to Rajya Sabha. That's point number one, very important point. It is not the personal decision of the President, basically on the recommendation of Council of Ministers headed by the Prime Minister. Number two, is it mandatory for the President to nominate these 12 MPs to Rajya Sabha? Yes, it is binding on the President to nominate these 12 MPs to Rajya Sabha. There is no discretion here. President has to nominate on the advice of the Prime Minister 12 MPs to Rajya Sabha from the fields of art, literature, science, social service. Very important point. When we look at this category, art, literature, science, social service, is this list illustrative or is this list exhaustive? Now, what's the difference between illustrative list and exhaustive list? If it is exhaustive, that means President cannot nominate anyone beyond this category. If it is exhaustive, that means President has to nominate only people from art, literature, science, social service. If it is illustrative, that means this is not an exhaustive list. This is not a rigid list. That means President can nominate somebody even if this person does not belong to the field of art, literature, science, social service. And this list is basically illustrative. And who has said this? Noted constitutional expert Soli Sorabji. There was a controversy when Sachin Ramesh Tendulkar was nominated to Rajya Sabha by the President from this category. But the question raised was that Sachin Tendulkar does not fall in this category from the field of art, literature, science, social service. Tendulkar does not fit into any of these criteria. So how was Sachin Tendulkar, who belongs to the field of sports, nominated to Rajya Sabha? Sunil Solanki said it is justified, it is legitimate, it is legal because this list is not exhaustive list. If this was exhaustive list, then Tendulkar could not have been nominated. But this list is illustrative. Illustrative in the sense that only examples are provided. Examples in the sense the Constitution says President may nominate MPs to Rajya Sabha from the fields such as art, literature, science, social service. That means President can go beyond this criteria as well and nominate any person who has done something exceptional in his own field. And that is how former Chief Justice of India, Justice Ranjan Gogoi, was also nominated to the Rajya Sabha by the President of India. Few months after his retirement as the Chief Justice of the Supreme Court of India, Ranjan Gogoi became the first Chief Justice of India, or the first former Chief Justice of India to be nominated to Rajya Sabha. Prior to Justice Ranjan Gogoi, we have had instances such as Justice Ranganath Mishra. He was also part of Rajya Sabha. But how? Justice Ranganath Mishra was given a ticket by the Congress party to contest Rajya Sabha election. So he entered Rajya Sabha from this elected category, not from the nominated category. Justice Ranjan Gogoi is the first Chief Justice of India, or the former Chief Justice of India, who was nominated to the Rajya Sabha by the President of India from this nominated category. But Justice Ranjan Gogoi, is he part of art, literature, science, social service? No. And how was Justice Ranjan Gogoi nominated to Rajya Sabha? The same explanation we can provide now as well. The same explanation given by former Attorney General for India. So, this list is only an illustration. It is not an exhaustive list. But was it justified that Ranjan Gogoi be nominated to Rajya Sabha? This is where some students have confusion. Justice Ranjan Gogoi, part of the judiciary, now appointed to legislature. Is there no separation of powers between legislature and judiciary? Can a member of the judiciary be part of the legislature? Does it not go against the separation of powers? There is simple logic to this. Justice Ranjan Gogoi, when he was the Chief Justice of India, while he was the Chief Justice of India, he could not be nominated to Rajya Sabha. Never. Justice Ranjan Gogoi's term got over. Now he's just like an ordinary man. And just like an ordinary man, he was nominated to the Rajya Sabha because he has done something good in the legal services. And it is because of his contribution to the law that he was nominated to the Rajya Sabha. But he's not a judge now. His term as Chief Justice of India is over. He's like an ordinary man who has done something exceptionally well in the field of law. That is why he was nominated by the President to the Rajya Sabha. Long story short, 250 is the maximum strength of Rajya Sabha. Out of 250, 238 are to be elected, 12 are to be nominated. Few important points. Number one, these 12 people are nominated to Rajya Sabha by the President, but it is not the personal decision of the President. Number two, it is binding on the President to nominate these 12 MPs. Number three, these 12 nominated MPs are from the fields of art, literature, science, social service, but these nominated MPs can be from any field. Subramaniam Swamy was nominated to Rajya Sabha. Swapan Das Gupta was nominated to Rajya Sabha. This list is not exhaustive list. This list is an illustrative list. That means example is provided by the Constitution that the President can nominate 12 MPs to Rajya Sabha from the fields such as art, literature, science, social service. That means President can go beyond these fields as well. This is about nominated category. 12 MPs nominated to Rajya Sabha by the President of India. What about these 238 elected MPs to Rajya Sabha? These 238 MPs who are to be elected to Rajya Sabha, 229 are to be elected from the states and 9 are to be elected from union territories. This was the position on August 2019. After 2019, Jammu and Kashmir state was downgraded, bifurcated into two union territories. Union territory of Jammu and Kashmir, union territory of Ladakh. But Ladakh is a union territory which will not have a legislative assembly. That means it's just like Chandigarh, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli. But Jammu and Kashmir is a union territory with a legislative assembly. It will have a legislative assembly. And these MPs to Rajya Sabha are elected by the state legislative assemblies. Remember this point. If 238 are to be elected to Rajya Sabha, these 238, who will elect them? Legislative assemblies. That means MLAs who are there in legislative assemblies, they will vote and they will get these MPs elected to Rajya Sabha. But what about union territories? There are only 3 union territories right now where we may have a legislative assembly. Delhi has a legislative assembly, Puducherry has a legislative assembly, Jammu and Kashmir will have a legislative assembly. That means not all union territories have legislative assemblies. That is why prior to August 2019, Parliament had reduced this number to 4. Which means since all union territories do not have a legislative assembly, that means legislative assembly MLAs cannot elect MPs to Rajya Sabha. Which means there are only 2 states as of August 2019 which have a legislative assembly. One is Delhi, other is Puducherry. No other union territory had a legislative assembly. Since legislative assembly MLAs, they elect MPs to Rajya Sabha. In other union territories, there are no legislative assemblies, there are no MLAs, so there is no point in providing them representation in Rajya Sabha. But there are 2 union territories which have a legislative assembly. Let's provide them representation in Rajya Sabha. And 3 MPs were sent to Rajya Sabha from Delhi union territory, and 1 MP was sent to Rajya Sabha from Puducherry union territory. Long story short, if 238 is the number of MPs elected to Rajya Sabha, how are these MPs elected? These MPs are basically elected when MLAs in the state legislative assemblies, when they vote and elect their MPs to Rajya Sabha. So Constitution has empowered the Parliament that you can regulate the number of MPs from union territories. You can regulate. We are providing 9 MPs to Rajya Sabha, but Parliament, you can regulate this number. And Parliament in its wisdom thought that since there are only 2 union territories which have legislative assemblies, one is Delhi, the other is Puducherry, so we will provide representation to only Delhi and Puducherry in Rajya Sabha. 3 will be from Delhi, 1 will be from Puducherry. That means this number 9 was reduced to 4, which means 229 plus 4 means 233. 233 plus these 12, which means 245. That means the maximum strength of Rajya Sabha is 250. But the existing strength, the current strength of Rajya Sabha is 245 because Parliament has regulated the number of MPs to Rajya Sabha from union territories. Originally 9 were provided, but now only 4 were provided. 3 from Delhi, 1 from Puducherry. Something else happened. Jammu and Kashmir, as I told you, was converted into that of a union territory, then bifurcated into union territories. Union territory of Jammu and Kashmir, union territory of Ladakh. Ladakh is a union territory without a legislative assembly, but Jammu and Kashmir is a union territory which will have a legislative assembly. When it will have a legislative assembly, that means it will be just like Delhi and Puducherry. When it is just like Delhi and Puducherry, that means J&K should also be provided representation in Rajya Sabha. There were already 4 MPs in Rajya Sabha from the state of Jammu and Kashmir. But when J&K was converted into a union territory, it was told that these 4 MPs will now be the representatives of the union territory of Jammu and Kashmir, which means now the scales have tilted. Which means now this number has changed. From states we have 225 MPs to Rajya Sabha because 4 from J&K. Chandigarh state now. We had 4 MPs from Union Territories of Delhi and Puducherry. Now with the addition of 4 MPs from the Union Territory of Jammu and Kashmir, this number is 8. So we have 225 plus 8, which again makes it 233, plus 12, the nominated category. So the number still remains 245. Long story short, the existing strength of Rajya Sabha is still 245. Maximum it is 250. Because of Jammu and Kashmir reorganization, what has happened? If there were 4 MPs from J&K state in Rajya Sabha, now these 4 MPs will continue. But they are not representing the state of Jammu and Kashmir, they are representing the Union Territory of Jammu and Kashmir. That means current status is, if we have 245 MPs in Rajya Sabha, we have 225 MPs from the states of India, we have 8 MPs from the Union Territories of India, 3 Union Territories, and we have 12 nominated MPs to Rajya Sabha. That means the existing strength still remains 245. This is the composition of Rajya Sabha. But now the question is, how are these MPs elected to Rajya Sabha? We know that these MPs are elected to Rajya Sabha by the states, by the state legislative assembly. That is why we call Rajya Sabha Council of States, because the states are directly represented in Rajya Sabha. How are these states directly represented in Rajya Sabha? For that we have Schedule 4 of the Constitution. What does Schedule 4 of the Constitution talk about? It talks about representation of states in Council of States, representation of states in Rajya Sabha. So Council of States, Rajya Sabha, how many MPs from Uttar Pradesh will be part of Rajya Sabha? Who says this? Schedule 4 of the Constitution. 31 MPs in Rajya Sabha will be from Uttar Pradesh. Where is it mentioned? Schedule 4 of the Constitution. 11 MPs in Rajya Sabha will be from Andhra Pradesh. Where is it mentioned? Schedule 4 of the Constitution. 7 MPs in Rajya Sabha will be from Telangana. Where is it mentioned? Schedule 4 of the Constitution. 4 MPs in Rajya Sabha will be from the Union Territory of Jammu and Kashmir. Where is it mentioned? Schedule 4 of the Constitution. That means Schedule 4 talks about representation of states in Council of States, representation of states in Rajya Sabha. But how does the election take place? Let me give you a mathematical solution to this, explanation to this. Let's say, for example, we have a state, let's say Gujarat, and in Gujarat we have 3 vacancies. That means 3 vacancies are to be filled. There are 3 vacancies, which means 3 MPs from Gujarat state are to be elected to Rajya Sabha. Let's assume for a while that 300 is the strength of the Legislative Assembly of Gujarat. How many vacancies do we have? 3 plus 1 plus 1. This is the formula. Total number of Legislative Assembly MLAs, members of Legislative Assembly, which means total number of MLAs divided by 3 is the vacancies, plus 1 plus 1. This formula is used to calculate the number of votes that a particular candidate should get in order to get elected to Rajya Sabha. Let me make it even simple for you. We have a state Gujarat, and in the state of Gujarat we have 300 MLAs. Clear? There are 3 vacancies. That means 3 MPs are to be elected from Gujarat to Rajya Sabha, which means if there are 10, 12, 13 candidates who are contesting the election, let's say there are 20 candidates who are contesting the election, and these 20 candidates are contesting for 3 vacancies, that means only 3 people will get elected to Rajya Sabha from the state of Gujarat. And out of these 20 people who are contesting the election, which are these 3 individuals who will get elected to Rajya Sabha? For that there has to be a formula to calculate the number of votes that a candidate should get in order to get elected to Rajya Sabha. This is the formula. So if it is 300 divided by 3 plus 1 plus 1, which is 300 divided by 4 plus 1, which is 75 plus 1, which is 76. I have not missed any mathematical step here. 76. That means out of these 20 candidates who are contesting elections to Rajya Sabha from Gujarat, any candidate who gets 76 votes will be elected to Rajya Sabha from the state of Gujarat. This is where it becomes even more interesting. Let's say, for example, election to Rajya Sabha from Gujarat is announced. Even before the voting takes place, we get to know who is going to win, who is going to lose. Let's say, for example, S. Shankar, the Union Minister for Foreign Affairs, External Affairs Minister, he got elected to Rajya Sabha from the state of Gujarat. How do we know, even before the voting, that these are the individuals who will get elected to Rajya Sabha from this particular state? Because here, we follow the system called proportional representation system. What is this proportional representation system? Let's say, for example, these total MLAs in Gujarat, what is the number? 300? 160 MLAs. They belong to BJP. Let's say, for example, 80 MLAs, they belong to Indian National Congress, and the remaining are independents. Let's say, for example, there are 20 candidates who are contesting this election. How many vacancies do we have? 3. How many votes should an individual get so that he or she is elected to Rajya Sabha? 76. Which means if BJP sets up 2 candidates, both of them will win. Why? 76 into 2 is equal to 152. BJP already has 160 MLAs. So when BJP sets up 2 candidates, 76 will vote for candidate A, 76 will vote for candidate B. Even then, there are 8 votes which are no longer required, which means proportional representation system. Which means Congress will at least have 1 MP from Gujarat in Rajya Sabha. That means even before the elections are conducted, we look at the proportional representation system. We look at the representation of a political party in that legislative assembly. So if 76 is the number of votes required for a candidate to win this election, Congress already has 80 MLAs. That means they have 4 additional votes. That means one of their candidate definitely will be elected to Rajya Sabha. That means in Rajya Sabha, we will have representation of political parties based on their proportion in legislative assembly. To make it even simple for you, how does election to Rajya Sabha take place? Rajya Sabha MPs are elected by the MLAs. That means if this is the legislative assembly, the MLAs of this legislative assembly will vote and they will elect their representative in Rajya Sabha. And this election takes place through a system called proportional representation system, something that we have discussed in the election of the president as well. And in this proportional representation system, what happens? That means a political party will have as many representatives in Rajya Sabha as is their strength in the legislative assembly. That means if BJP has 160 MLAs, it is sure that 2 of its candidates will be elected to Rajya Sabha. If Congress has 80 MLAs, it is sure that 1 of its candidates will be elected to Rajya Sabha. Proportional representation system. That is why we say even before the voting takes place, we get to know whether a political party will have its representative in Rajya Sabha or not. It's basically decided on the basis of the fact that this political party should have the number of votes required, number of MLAs required to get this candidate elected to Rajya Sabha. Now let us look at something else. We say Rajya Sabha has some special powers, and these special powers we say are exclusive to Rajya Sabha. That's why we call it a special power. That means these powers are not available to Lok Sabha. There are 3 such powers which are exclusive to Rajya Sabha, which are not available to Lok Sabha. Power number 1, Article 67, Clause B of the Constitution of India. Vice President is to be removed from his office. How is the Vice President removed? We have discussed. Vice President's removal can only be initiated in Rajya Sabha, which makes it the exclusive power of Rajya Sabha. Vice President is removed from his office when the Rajya Sabha passes a resolution by special majority, and then this resolution should be accepted by Lok Sabha. That means Lok Sabha will pass this resolution by simple majority. And if it is done, then Vice President is removed from his office. Then what sort of special power does Rajya Sabha have when it comes to the removal of the Vice President of India? This is the special power. The special power is that the resolution calling for the removal of the Vice President of India can be initiated only in Rajya Sabha. If Rajya Sabha passes a resolution by special majority, this resolution should only be acceptable to Lok Sabha. That means Lok Sabha should pass a resolution by simple majority and Vice President is removed from his office. That means the special power for Rajya Sabha is that a resolution calling for the removal of Vice President of India can only be initiated in Rajya Sabha under Article 67 clause B. Second special power which is not available to Lok Sabha but it is available to Rajya Sabha is Article 249 of the Constitution. What is Article 249? We have union list, state list, concurrent list. Parliament has the power to legislate on any item mentioned in the union list. Both Parliament and the state legislature has the power to make law on any item mentioned in the concurrent list. But state legislature has the power to make law on any item mentioned in the state list, but only in normal circumstances. Which means in normal circumstances, the state legislative assembly has the power to make law on any item mentioned in the state list. That means on law and order, land, agriculture, gambling, police. In normal circumstances, the state legislature has the power to make laws on any item mentioned in the state list. But can Parliament make a law on any item mentioned in the state list? Normally, this power is given to the state legislature. You make law on any item mentioned in the state list. But can Parliament, which is the union legislature, make a law on any item mentioned in the state list? Yes. And that special power is given to Rajya Sabha. If Rajya Sabha passes a resolution under Article 249 by 2/3 of the members present and voting, and if Rajya Sabha says it is in national interest that Parliament should pass a law on an item mentioned in the state list, then Parliament can make a law on this item mentioned in the state list. Long story short, state legislature in normal circumstances has the power to make law on any item mentioned in the state list. But can Parliament make a law on any item mentioned in the state list? Yes. That power is given to the Rajya Sabha to decide. If Rajya Sabha passes a resolution by 2/3 of the members present and voting and says that it is in national interest that Parliament should pass a law on state list, then Parliament becomes empowered to pass a law on the state list. And the validity of this law is 1 year. Can this law, which the Parliament has passed for that state, on that state list, can this law continue beyond a period of 1 year? Yes. But for that, another resolution should be passed by 2/3 of the members present and voting. If another resolution is passed, this law can be extended for another period of 1 year. To make it even simpler for you, what are the special powers of Rajya Sabha? That means when we say special powers, that means these powers are exclusively available to Rajya Sabha. They are not available to Lok Sabha. Power number 1, 67 clause B, the removal of the Vice President of India. The resolution calling for the removal of Vice President of India can be initiated only in Rajya Sabha. Special power number 2, Article 249. Parliament can make a law on an item mentioned in the state list. If Rajya Sabha, under Article 249, passes a resolution by 2/3 of the members present and voting, saying it is in the national interest that Parliament should frame a law for that state, Parliament can frame a law for that state, even if that subject is under the state list. That's another special power of Rajya Sabha. And why is this power given to Rajya Sabha? Because Rajya Sabha is the Council of States. It represents states in the Parliament. And third special power of Rajya Sabha, which is available to it and is not available to Lok Sabha, is Article 312 for the creation of an all India service. How many all India services do we have? 3. We have Indian Administrative Service, we have Indian Police Service, we have Indian Forest Service. These are the 3 all India services. Can another all India service be created? Let's say Indian Education Service. Can any other all India service be created? Yes. Who can create a new all India service? Parliament. This is where many people have confusion, but don't be confused. A new all India service can only be created by Parliament. But Parliament cannot create on its own unless and until under Article 312, Rajya Sabha passes a resolution, and that resolution is passed by 2/3 of the members present and voting. When the Rajya Sabha passes a resolution under Article 312 of the Constitution by 2/3 of the members present and voting, only then Parliament can create a new all India service. Because when you look at all India service, IAS, IPS, they are recruited by the center, they are controlled by the center, they can be dismissed by the center. But where do they work? They work in the states. So as if they are eyes and ears of the central government in the state. Some people say the concept of all India service is against the concept of federalism, because federalism would mean straight distribution of powers. But if the center is recruiting officers, training officers, controlling officers, but these officers are working in the states, they are posted in the states, does it not mean that our federalism is biased in favor of center, is biased in favor of a strong center? That's how it is. And that's why if a new all India service is to be created, states have to give their consent. How do states give their consent? They are Rajya Sabha. Since Rajya Sabha is the Council of States, since Rajya Sabha represents the states in the Indian Parliament, unless and until Rajya Sabha passes a resolution under Article 312, that too by 2/3 of the members present and voting, Parliament cannot create a new all India service, which means only parliamentary law can create a new all India service. But Parliament cannot initiate creation of all India service on its own unless and until Rajya Sabha passes a resolution by 2/3 of the members present and voting. These are the special powers of Rajya Sabha, which are not available to Lok Sabha. We have Article 67 clause B, Article 249, and Article 312 of the Constitution. Now let's look at something very interesting, and this is where it becomes important for your mains examination as well. We will look at a topic: what is the relevance of Rajya Sabha? What is the relevance of this second chamber of Indian Parliament? The logic of having a second chamber of Indian Parliament was this. What is the logic? We say Lok Sabha is a popular house of the people. It represents the popular sentiments of the people of this country. Because how are these Lok Sabha MPs elected? After every 5 years in a general election, people come out in large numbers, vote, and they elect their representatives in Lok Sabha. That means Lok Sabha MPs, they are directly elected by the people. They are directly in contact with the people as well. So they can be under the control of the people. In a sense, any demand that people make, these MPs of Lok Sabha, they will be under a lot of pressure to realize that demand, to meet those expectations. Which means, let's say for example, this rapes are happening in the country, unfortunately. And let's say for example, there is a demand by the people of this country that all those rapists, there should be chemical castration of them. That means these rapists should be chemically castrated. That is the demand of the people of this country. Who will make a law that all those rapists who are proven guilty, they will be chemically castrated? The law will be made by the Parliament. That means Lok Sabha as well as Rajya Sabha. Lok Sabha, since it is a popular chamber, it will come under the influence and the pressure of the public. Public will pressurize these MPs to Lok Sabha that we have elected you. Get this law passed and let's have chemical castration of those who are the proven rapists. and ultimately Lok Sabha MPs will buckle, they will succumb to the pressure, and ultimately they will pass this bill which talks about chemical castration of rapists. But this law may be bad. This law may be bad in the sense that even the rapists, they also are the citizens of this country. I'm not justifying them. They also have the same rights when it comes to access to justice. That means it should be proven in a court of law that they are the rapists. Only then we can punish them. Some people would say that even death sentence is wrong. Death sentence also should not be given because punishment should be such that it should act as a deterrent. Punishment should be such that it should reform an offender. Death sentence does not act as a deterrent, so why have death sentence? Death sentence cannot reform an offender because if I'm sentenced to death, I am too dead to be reformed. So death sentence, some people say, does not act as a deterrent because these terrorists, for example, they're not scared of death. They use their suicide vests, and whenever police comes to arrest them or army comes to arrest them, they blow themselves up. So they're not scared of death. They're scared of arrest. So death is not a deterrent. So why should we have death sentence? Second, death cannot reform an offender because the golden rule of criminal justice system is we should reform an offender as well. He may have committed a crime now, but tomorrow he may be an asset to the society. Let him serve the punishment in jail, and we will analyze whether he is fit to be thrown back to the society or not, whether he is fit to reintegrate with the society or not. And that is how in jail he should be able to reform himself as well. And once he or she is reformed, we can send this person back to the society. That means the objective of punishment is two. There are two objectives to punishment. One, punishment should be such that it should act as a deterrent, so that tomorrow no other individual can commit the same crime again, and it should reform the offender. Some people say death sentence does not act as a deterrent. It cannot reform an individual because he is too dead to be reformed. So why have death sentence in the first place? And there are also others who say chemical castration is not a good thing to do. Let's assume for a while that chemical castration is not a good thing. Let's assume for a while. And the people of this country are demanding chemical castration. Lok Sabha passes this bill. Why? Because Lok Sabha is under the control, influence of the people. Because people directly elect Lok Sabha MPs, they are directly in touch with them. So there's a popular demand. Chemical castration. This popular demand should be met by Lok Sabha MPs because they are the popular house. And Lok Sabha passes this bill, chemical castration bill. All the rapists are to be chemically castrated. This bill will go back to Rajya Sabha, but Rajya Sabha we call it House of Elders. Rajya Sabha will discuss this bill, ponder over this bill. It may not act on this bill for some time. It will delay the passage of this bill. Why? Let the anger subside. When the anger subsides, we will quickly be done away with this bill. We will not get this bill passed. Why? Because this bill is wrong. This bill is bad. This law, if it is passed, would be wrong, would be unreasonable, would be unjustified. Which means if there was only one chamber, if there was only one house, Lok Sabha, which is the popular house, which is under the popular control of the people of this country, a hasty law may be passed by the Lok Sabha. And to prevent Lok Sabha from committing such an error of passing a hasty law, we have the Rajya Sabha. And Rajya Sabha will delay the passage of this bill because Rajya Sabha is the House of Elders. Rajya Sabha will delay the passage of this bill. Public anger will subside and Parliament will be saved from committing a blunder. This is why Rajya Sabha was envisaged by the Constitution makers. That means relevance number one of Rajya Sabha is it prevents the Parliament from passing a hasty bill. Since Lok Sabha is the popular chamber of the Parliament, it will come under the influence, the popular mood of the people, but Rajya Sabha can delay the passage of the bill because Rajya Sabha MPs are not directly elected by the people. And that is how Rajya Sabha was viewed as a body, as an institution, as a house of the Indian Parliament, which will delay the passage of hasty bills. That's relevance number one. Relevance number two, all bills passed by the Parliament shall have to be passed by both Lok Sabha as well as Rajya Sabha and then signed by the President as well. We say President is an integral part of the Parliament. Why? Because no bill can become a law, can become an act unless and until President gives his assent. That means a bill should be passed by Parliament. Parliament has three organs, President, Rajya Sabha, Lok Sabha. That means the bill should be approved by all these three institutions. The bill is passed by Lok Sabha, then Rajya Sabha, or the bill is passed by Rajya Sabha, then Lok Sabha, then signed by the President of India. This bill is passed, this bill becomes the act, this bill becomes the law of the land. But when you look at this way, there are some bills where there can be disagreement. Let's say, for example, a bill is passed by Lok Sabha, but this bill is not passed by Rajya Sabha. Rajya Sabha does not agree with this bill. And if Rajya Sabha does not agree with this bill, there is a deadlock. And if there is a deadlock, to resolve this deadlock, we have a joint session of Indian Parliament. What is this joint session of Indian Parliament? Let's say, for example, we have 543 MPs in Lok Sabha. We have 245 MPs in Rajya Sabha. What is the total? We have 788 MPs in Indian Parliament. So if this is a bill on which there arises a deadlock, which is that Lok Sabha wants this bill to be passed, but Rajya Sabha does not want this bill to be passed, on this particular bill there is a deadlock. How do we resolve this deadlock? What President does? He convenes the joint session of Indian Parliament, which means members of both houses of the Indian Parliament are present together. And in this joint session, this bill will be voted upon. And in this joint session, if the bill is passed by simple majority, the bill is passed. But look at the numerical majority of Lok Sabha. Lok Sabha has 543 MPs. Rajya Sabha has 245 only. The numerical majority of Lok Sabha prevails in this bill. That means it is the will of Lok Sabha which prevails in this bill. That means it is the will of the Lok Sabha which prevails in this joint session of Indian Parliament. That means this bill will be passed because it is the will of Lok Sabha. Some people say that Rajya Sabha has no relevance because when joint session of Indian Parliament is convened, the numerical majority of the Lok Sabha prevails. Rajya Sabha has an inferior role to play. That is why Rajya Sabha has no relevance. But we need to understand that Rajya Sabha has an equal role when it comes to a constitutional amendment bill. A constitutional amendment bill should be passed by both houses of the Indian Parliament, that too separately. That means for a constitutional amendment bill, there can be no joint session of Indian Parliament. And if indeed, joint session of Indian Parliament is something which says that Rajya Sabha is inferior, but only 3 times in the past, joint session of Indian Parliament has been convened. On Jobby Bill, on Banking Bill, on Quota, Prevention of Terrorism Act Bill. On these 3 bills, only joint session of Indian Parliament has been convened. That means from 1950 till 2020, only 3 joint sessions of Indian Parliament has been convened, which proves beyond any reasonable doubt the relevance of Rajya Sabha. Which means, what is the relevance of Rajya Sabha? Number one, relevance is it prevents the hasty bills from being passed by the Parliament. Number two, all bills are to be passed by Rajya Sabha as well. If joint session of Indian Parliament is something that is viewed that it is an inferior role of Rajya Sabha, but only 3 times a joint session of Indian Parliament has been convened. And a constitutional amendment bill shall have to be passed by both houses of the Indian Parliament, that too separately. There are a few areas where Rajya Sabha has an inferior role. One is money bill. It is the bill of Lok Sabha which prevails in a money bill, and we will discuss slightly later what is a money bill and what is the role or inferior role of Rajya Sabha in a money bill. Second, adjournment motion, no conference motion, censure motion. All these types of motions can be introduced only in Lok Sabha, cannot be introduced in Rajya Sabha. And this proves that Rajya Sabha has an inferior role. But please understand one thing. Ours is a parliamentary form of democracy. And in a parliamentary form of democracy, Council of Ministers is accountable to Lok Sabha, not to Rajya Sabha. So that doesn't mean Rajya Sabha has an inferior role. And all these motions we are going to discuss in this chapter itself. And there's another important role, and that's what we call bargaining federalism. And what is this concept of bargaining federalism? We have seen the emergence of coalition governments. For example, in 1990s, VP Singh headed a coalition government. Narasimha Rao also was supported by various political parties. I.K. Gujral, Deve Gowda, Atal Bihari Vajpayee. Then we saw Dr. Manmohan Singh heading a coalition government for 10 years, 2 terms. It was only in 2014 that we saw a single party getting the absolute majority to form the government. Then again in 2019, a single party emerging as a party with absolute majority to form the government on its own at the center. But even then, in Rajya Sabha, the government, which is in power at the center, may not have the majority. That means the government may have a majority in Lok Sabha, but the government may not have a majority in Rajya Sabha. And in Rajya Sabha is the Council of States. The states are represented in Rajya Sabha. So this government at the center, if it has to get a bill passed in the parliament, that means this bill should be passed by Lok Sabha. This bill should be passed by Rajya Sabha as well, right? But this government may not have a majority in Rajya Sabha. What this government will do, it will reach out to states. It will reach out to West Bengal. It will reach out to Tamil Nadu. It will reach out to Odisha. It will reach out to Andhra. It will reach out to Telangana. It will reach out to those states which are controlled by regional political parties, where the government is of regional political parties. Regional political parties. Now they are talking to the central government, and now they are bargaining. Bargaining in the sense, we will support their central government. I'm a regional party. I will support you on this bill, but what will I get? I need something for my people. So give us this amount of package. Or one railway line should also be opened. Or for our flood hit victims, this should be the amount of money released. Or for our industries, this should be the package released. So now these regional parties, they're bargaining with the center. When regional parties bargain with the center, who is getting strengthened? Regional political parties, which means states are getting benefited. When states are getting benefited, it's always a benefit for our federalism, and that is what we call bargaining federalism. That means the Rajya Sabha plays an even important role in giving this bargaining federalism a push. Because when a party is in power at the center, it may not have the majority in Rajya Sabha, despite the fact that it has a thumping majority in Lok Sabha. And to get key bills passed in the parliament, this central government now reaches out to the regional players. It reaches out to regional political parties, and thereby strengthening the federalism, bargaining federalism, because the states will bargain good terms for their respective states. That's the relevance of Rajya Sabha. But few quick points here before we end the discussion on Rajya Sabha. Number one, Rajya Sabha is the Council of States. The Hindi term is Rajya Sabha. But Rajya Sabha is the permanent house of Indian Parliament. When we say it is permanent house of Indian Parliament, that means it is not subject to dissolution. That means Lok Sabha can be dissolved, but Rajya Sabha cannot be dissolved. It will remain the permanent house of Indian Parliament. That's statement number one. Statement number two, 1/3 of the members of Rajya Sabha, they retire every 2 years. That's statement number two. Statement number three, Constitution does not talk about the term of a Rajya Sabha MP. It is the Representation of the People Act which talks about the term of a Rajya Sabha MP. And the term of Rajya Sabha MP is 6 years. Clear? And that is why 1/3 of the MPs retire every 2 years, which means every 2 years, every 2 years, every 2 years. 1/3 MPs retire. That means at no point Rajya Sabha will be empty. That means its permanent character is ensured, which means it is not subject to dissolution. When we say Rajya Sabha is the permanent house of Indian Parliament, if it is slightly difficult for you to understand, let me make it even simpler for you. For example, we are in 1952. Now we have Rajya Sabha. Now there are Rajya Sabha MPs who are elected. If, for example, all these 245 people are elected at the same time, which means their term of 6 years would be over at the same time, just like Lok Sabha, which means there will come a time, just like Lok Sabha is dissolved, Rajya Sabha will also be dissolved. So when Rajya Sabha is dissolved, how can we ensure the permanent character, permanent nature of Rajya Sabha? To ensure that in 1952, what happened? The President of India, he cut the term of 1/3 of the MPs. So 1/3 MP, they were made to retire after 2 years. When they were made to retire, that means these 1/3 seats are now to be filled again. When election was held in these 1/3 seats, all those who got elected, now their term was 6 years. Which means to ensure that there never occurs a time when Rajya Sabha is empty of its members. To make it even simpler for you, Rajya Sabha is the permanent house of Indian Parliament. How do we ensure that? We can ensure that there are MPs in Rajya Sabha for all times to come. That is why there are 1/3 MPs whose term is 6 years. 1/3 MPs term is 6 years. 1/3 MP term is 6 years. Clear? But when Rajya Sabha was convened for the first time, all the MPs elected, their term is 6 years. So there will come a point where all these MPs, their term is over and Rajya Sabha is empty of members. That is why President is empowered that you can cut short the term of MPs of Rajya Sabha. And what President said, that 1/3 of the Rajya Sabha MPs, they should retire after 2 years. And these 1/3 were chosen. That you retire after 2 years. How were these MPs chosen? Draw of lots. Lots were drawn, and whoever name came across from this draw, these MPs were asked that you retire. Your term is over after 2 years. They contested the election again. These seats, which are now vacant, now their term is 6 years. Clear? Now there is another lot, 1/3 of the MPs. They were also made to retire, but now after 4 years. How were these MPs chosen? Draw of lots. That means 1/3 of the MPs retire after every 2 years. But even then, the term of a Rajya Sabha MP is 6 years. In Lok Sabha and in legislative assemblies, there is reservation for SCs and STs. But there is no SC, ST reservation when it comes to Rajya Sabha. Very important point for your prelims examination. Fifth important point, the voting takes place through open ballot. What is open ballot here? In Rajya Sabha elections, state legislative assemblies, their MLAs, they vote. When they vote, they have to drop their vote in the ballot box. They have to drop their ballot papers into the ballot box. But before they drop their ballot papers into the ballot box, they have to show their vote to the representative of their political party. Which means if I'm from the BJP and I have to vote in the Rajya Sabha election, I am an MLA. As an MLA, I am the voter in Rajya Sabha election. And when this ballot paper is given to me, I mark my preference that I am voting for the BJP candidate to Rajya Sabha. And when I have to drop this ballot paper into the ballot box, before I do that, since the voting is open ballot, I have to show it to the representative of the BJP. See, I'm voting in favor of the BJP. Since I'm part of the BJP, you told me vote for the BJP. I'm voting in favor of the BJP. This is open ballot voting. That means in Rajya Sabha, the elections take place through open ballot.
Now let us look at Lok Sabha.
Lok Sabha, House of the People, for which we have a Hindi name, Lok Sabha. Let's assume for a while we are talking about August 2019. What is the composition of Lok Sabha? 552 is the maximum strength of Lok Sabha. Out of 552, 530 are to be elected from the states, 20 are to be elected from union territories, and 2 are to be nominated by the president. And president nominates 2 MPs from Anglo-Indian community. That means president used to nominate 2 MPs from Anglo-Indian community to Lok Sabha. Constitution said if the president is satisfied that Anglo-Indian community is not sufficiently represented in Lok Sabha, if the president is satisfied that Anglo-Indian community is not sufficiently represented in Lok Sabha, what he can do, he may nominate 2 MPs to Lok Sabha from Anglo-Indian community. This was the position. But to this number, Constitution also empowered the parliament that you can regulate the number from union territories, just like it has the power with respect to Rajya Sabha. In a similar fashion, Constitution empowered the parliament that you can regulate the number of union territory representation in Lok Sabha. And parliament did that. 530 from states, 13 from union territories, 2 Anglo-Indians. That means then the existing strength was 545. On 543, there would be elections. 2 would be nominated from Anglo-Indian community. So the existing strength as on August 2019 was 545. Then what happened? August 2019, Jammu and Kashmir was converted and bifurcated into union territories. Union territory of Jammu and Kashmir, union territory of Ladakh. Ladakh will have 1 MP to Lok Sabha. Jammu and Kashmir union territory will have 5 MPs to Lok Sabha, which means now the number of MPs from union territories in Lok Sabha would be 19 and 524 from the states. That means the total still remains 543 plus 2 nominated MPs, which means the existing strength was 545, 530 from the states. But now J&K was taken away from a state made into 2 union territories. That is why from 530 minus 6 from Jammu and Kashmir, the number is 524 plus 6 from J&K and Ladakh, the number goes up to 19. But existing strength still remains 543. That means on 543 there will be elections. But then what happened? 104th Constitutional Amendment Act was passed. Because in Lok Sabha, in legislative assemblies, there are going to be seats reserved for SCs and STs. This reservation would have ended in 2020. But 104th Constitutional Amendment Act, it extended this SC/ST reservation till 2030. That means 104th Constitutional Amendment Act, what it did, it extended the SC/ST reservation till the year 2030. This Amendment Act did something else. 2 MPs from Anglo-Indian community were to be nominated to Lok Sabha. This reservation for Anglo-Indians would have ended in the year 2020. This reservation for Anglo-Indians was not extended, which means 104th Constitutional Amendment Act. What it did, it extended the SC/ST reservation by 10 more years till 2030. But it did not extend the Anglo-Indian reservation by the same year. But it did not extend the Anglo-Indian reservation, which means Anglo-Indian reservation, SC/ST reservation, it would have ended in the year 2020. SC/ST reservation was extended till 2030. Anglo-Indian reservation was not extended. That means now there is no Anglo-Indian reservation, which means now what is the existing strength? The existing strength becomes 524 from the states, 19 from the union territories, which makes it 543. And how are these 543 members elected? General election. After every 5 years, people come out in large numbers and vote for their representatives. And through first past the post system, MPs are getting elected to Lok Sabha, and that is how MPs are elected to Lok Sabha by the people of this country directly. So there is a direct election when it comes to the members of Lok Sabha. So this was brief about introduction to Parliament. What are the multifarious roles played, performed by Indian Parliament? Indian Parliament, President, Rajya Sabha, Lok Sabha. We talked about Rajya Sabha, we talked about Lok Sabha. Now let's club the two together, and we will now look at what the qualifications required for someone to contest election to Lok Sabha, to contest election to Rajya Sabha. What are the disqualifications as well? All this we are going to discuss now.
Now, in order to be elected as member of Lok Sabha, what is the qualification? Qualification is you have to be an Indian citizen. Qualification is you must have completed 25 years of age. In Rajya Sabha it is 30. In Lok Sabha it is 25. That means these are the 2 important qualifications that the Constitution prescribes. But you should not only be qualified. Suppose I'm qualified to contest the election, and I win the election, and I became member of either Lok Sabha or Rajya Sabha. After my election, I should not come under disqualification as well. That means after my election, I should not be subject to disqualification as well. That means members of the parliament can be disqualified as well. And what are the grounds? Ground number 1, change in the nature of citizenship. I'm an Indian. I contested the election, but suddenly I acquired citizenship of a foreign country. How can a foreigner be entrusted with the job, with the task of lawmaking in a country? Clearly that is not possible. So if there is a change in the nature of citizenship of a particular member of parliament, he shall be disqualified. Disqualification criteria number 2, mental unsoundness. Lawmaking is a serious business. It's a responsibility, a big responsibility. Now suddenly, I as a member of parliament, I turn mentally unsound, mentally sick. I cannot be in a position to make good laws, to make just laws, because I do not have that mental capacity, mental faculty to make laws for the rest of the population of this country. You may sympathize with me, you may show empathy towards me, but clearly I cannot be entrusted to this important business of lawmaking. So if I turn mentally unsound, disqualified. Third, a judge insolvent. What if I turn bankrupt? I have no money left. Ultimately, don't you think there will be a conflict of interest? Conflict of interest in the sense that I can pass some laws based on which I can get money from the people. To resolve this conflict of interest, the Constitution has provided that if an individual turns bankrupt, if an individual turns a judge insolvent, he or she shall be disqualified as well. Fourth criteria, if he is disqualified under any law made by the parliament. What does that mean? Lalu Prasad Yadav, he was convicted in fraud scam. The punishment was for more than 2 years. Immediately on the date of his conviction, he was disqualified. Rashid Masood, who was charged in the illegal sale and selling of MBBS seats, immediately on the date of his conviction, for a term of more than 2 years, disqualified. That means if a member of parliament is convicted in any court of law, by a district court, by a high court, by a supreme court, if he is convicted in any court of law, and the sentence is given, which is more than 2 years, then immediately on the date of his conviction, he can be disqualified from being member of the parliament. That means qualifications we know, but you should not also be subject to disqualification. And what are these grounds of disqualification? These are the grounds that we have talked about. But perhaps the most important ground is that you should not be holding an office of profit. So let's talk about what this office of profit primarily means. In England, Queen was the head of the executive, Queen is also the head of the legislature. That means Queen is an integral part of both executive as well as legislature. Parliament was provided, people directly elected members to the parliament. Now these parliamentarians have a duty. They have a duty towards their people. The people who elected them. One of the principal duty also is to criticize the executive, is to criticize the government. But what was Queen doing? Queen was appointing these legislators to some executive bodies. That means an additional post was given to these legislators. These legislators were appointed to an executive post which was created by the Queen. Now, do you think that these legislators will criticize the Queen? They will not criticize the Queen, right? Because their duty is to criticize the Queen, to represent the people who elected them to the legislature. But their interest is somewhere else. Their interest is that because they were appointed to an executive post by the Queen can at any point in time remove these members as well if you are criticizing the Queen. That means the duty clashed with the interest. That is what we call an office of profit. To prevent such a situation, the British Parliament passed a law. It stated that a member of Parliament cannot hold any post under the government. Member of Parliament is primarily responsibility, duty to pick up issues, to raise up issues that are faced by the people of their own constituencies, and to enable them to perform this task in a better, effective, non-corrupt way is to insulate them from executive. How can you insulate them from the executive? You are barred from holding any post under the government, so that the duty and the interest do not clash with each other. If duties and interests clash with each other, ultimately it's going to sound a bit then the constitutional philosophy. Principally, this reason was also why the Constitution provided that any member of Parliament should also not hold any office of profit. What does that mean? A person shall be disqualified for being chosen as and for being a member of either house of the Parliament if he holds any office of profit under the government of India or government of any state, other than the office declared by the law not to disqualify its holder. What does that mean? Let me simplify it. You shall be disqualified if you are holding an office of profit. You shall be disqualified from being a member of Parliament if you are holding an office of profit. Other than those offices which the Parliament has said is not an office of profit. We will discuss all these cases one by one. But four things are to be kept in mind here. The first important point is the need. What was the need to incorporate this provision into the Constitution called office of profit? The need was, I'll dictate the statement, please have a look at it very carefully, to secure independence of the members of the Parliament and to ensure Parliament does not have the members who receive favours or benefits from the executive, that is the government, and who consequently, being under an obligation to the executive, might be amenable to its influence. This is what we discussed. That means a member of Parliament should not hold an office under the government because the government will exercise tremendous influence on this legislator, and the job of the legislator, which is to represent the needs, aspirations, and wishes of his own people, that can be flirted with. That is the reason why this office of profit was incorporated into the Constitution. But to understand it fully, four things must be proven. First, that he held an office. This office of profit is recently in the news. Tremendous controversy surrounding this office of profit because some members of Aam Aadmi Party are said to hold an office of profit. Let's discuss this in greater detail. First thing that must be proven is that he held an office. Now, what is an office? An office is an office which has an independent existence. For example, Jaya Bachchan, who was a member of Rajya Sabha from Samajwadi Party. Mr. Jaya Bachchan was also appointed as chairperson of UP Film Development Corporation. Matter went to the court, a petition was filed, the court was told that Mr. Jaya Bachchan should be disqualified from being member of Rajya Sabha because she holds an office of profit. And what is this office of profit? Because she is the chairperson of UP Film Development Corporation. That means this is an office which she is holding apart from being a legislator, so she should be disqualified. The court said, the first thing that must be kept in mind, whether she held an office or not. And what is an office? An office is an office if it has independent existence. That means Jaya Bachchan is appointed to this UP Film Development Corporation. If Jaya Bachchan is removed from this office, will this office continue or will this office be eradicated? The office will continue. That means someone else will be appointed as chairperson of UP Film Development Corporation. That means this office has an independent existence. That means if a legislator is appointed to an office and this office has an independent character, independent existence, that means the life of this office does not depend upon its holder. Holders may change. The holders of this office may change, but the office will remain in existence. That means it is an office. So first thing to be proven is that whether it is an office or not. If there is an office whose life is dependent upon its holder, that means I am a legislator. I am appointed to a body called X. But if I am appointed to this body X, as soon as I resign from being a legislator or my term expires, this office also is gone. This office will not have its independent existence. That means this office is dependent upon its holder. That means then it is not an office. It is just an additional responsibility which is given to me by virtue of me being a legislator. Office of profit. You shall be disqualified if you are holding an office of profit. What is this office of profit? First thing is, what was the need? To insulate legislators from the executive. To have some sort of separation of powers. The Constitution said, let's bar those individuals who are holding office of profit from continuing as a legislator. But how can you disqualify these holders? For that, four things must be proven. Permission number one, that he held an office. An office is an office if it has an independent existence. If the life of this office depends upon its holder, then it's not an office. But if the office has an independent existence of its own, that means its existence is not determined. That means its existence is not dependent upon its holder. That means even if the holder resigns, even if the holder is suspended, even if the holder is torn, despite these facts, the office continues to have its own existence. That means it is an office. If it is an office, at the same time, it must be an office of profit. What does that mean? Jaya Bachchan, when she presented her case before the Supreme Court, the court told her that yes, you are holding an office of profit. Jaya Bachchan said, how can I be holding an office of profit? Yes, UP Film Development Corporation has its chairperson and I am the chairperson. But I do not draw the salary. I do not use the government bungalow. I do not have a chauffeur-driven car. That means there are benefits which I am not taking. There are benefits attached to this office, but I am not taking any of these benefits. So there is no profit available to me. There is no profit available to me. How can this office be treated as an office of profit? Supreme Court said no. It doesn't matter. What matters is pecuniary gain. The Supreme Court asked Judge Jaya Bachchan, is this salary attached to this office of UP Film Development Corporation? She said yes, but I'm not taking the salary. Court said doesn't matter. The salary is attached? Yes. Second, are you provided an official bungalow attached attached to this office? She said yes, but I'm not taking that residence. Because I'm not taking that residence, that means it should not be office of profit. Court said doesn't matter. What is to be understood here? Court said is accruability. That means if you are holding this office for 3 years, you're not drawing any salary. You're not drawing any perks. You're not drawing any benefits. But at any point in time, you can accrue all these benefits in one single go. You can tell the government for 4 years, for 3 years, I have not drawn any salary. You can tell the government that for 3 years, 4 years, I have not drawn any salary from the government. Not giving the salary. The government is obligatory. It is binding on the government to provide you that money. So whether you are taking the money or not doesn't matter. What matters here is pecuniary gain. If there is a pecuniary gain, that means benefits are attached to this office. Whether you see those benefits, you take those benefits, doesn't matter. But there are benefits attached to this office. This is an office of profit. So first thing to be proven is whether this is an office. Second thing to be proven is whether it is an office of profit. Whether you are drawing the salary or not doesn't matter. Is salary attached to this office? It is an office of profit. Bungalow is to be given to the holder of this office. Now whether you are staying in the bungalow or not doesn't matter. Bungalow is attached. It is an office of profit. Benefits. Perks. Office accommodation for UP Film Development Corporation. Do you have an office? Yes. That means it is an office of profit. So first thing to be proven is whether it is an office. Second, whether it is an office of profit. Third, this must be an office of profit under the government of India or a state government. This is recently was member of parliament. But he was also the chairperson of UD Group, United Breweries. That means he was holding this office. It was an office, that means it has its independent existence. At the same time, there were benefits from this office. Salary, airport travel, hotel accommodation, everything was there for Vijay Mallya. That means it is an office of profit. But UB Group is not an office of the government. UB Group is not created by the government. UB Group is not funded by the government. If it is not funded by the government, if it is not created by the government, if government has no authority on this particular institution, that means it is an office of profit, but it is not an office of profit under the government of India or government of a state. So three things. First, it must be an office. Second, office of profit. Third, office of profit under government of India or government of a state. Fourth condition. The office should be other than an office declared by parliament by law, not to disqualify its holder. The Supreme Court has explained very beautifully what is an office of profit. The Supreme Court said first thing it must be proven that he held an office, that it was an office of profit, and that it was an office under the government of India or a state government. The court was asked, how can we prove whether it is an office of profit under the government or not? Supreme Court said these are the guidelines. Guideline number 1. Is this office created by the government? No, that is not an office of profit. If this office is created by the government, then it is an office of profit. If it is created by the government of India, is the appointment made by the government? Yes, it is an office of profit. Is the government having the power to remove that officer? Yes, it is an office of profit. Does government have the responsibility of evaluating the performance of its holder? Does government look into how you are performing by holding that office? Is performance appraisal done by the government? Then it is an office of profit. So these conditions are to be kept in mind while deciding whether an office is an office of profit or it is not an office of profit. But there can be many offices which are offices of profit. That means it is an office. It is an office of profit. That too under the government of India or government of a state. But even if a legislator is holding this office, this legislator cannot be disqualified. Why? Because this office has been declared by the parliament by law as not an office of profit. For example, ministers. You are a minister. You are appointed by the government. You are appointed by the president. You are also a legislator. Are you not appointed by the government? Because you are part of the government. But ministers are not deemed as an office of profit. Leader of opposition. Salary is provided. The leader of opposition has a cabinet minister status. A bungalow is provided. A car is provided by the government. That means it is under the influence of the government. But this office has been declared as not an office of profit. Pranab Mukherjee, in 1990s, he was aspiring to become the prime minister. But ultimately, it was P.V. Narasimha Rao who was appointed as the prime minister. Then Pranab Mukherjee was sulking. Someone told the prime minister that he can appoint Pranab Mukherjee as the deputy chairperson of the planning commission. But deputy chairperson of planning commission is appointed by the prime minister. Bungalow provided by the government. Salary provided by the government. Status provided by the government. That means it is an office of profit. An amendment to this law was done, and this office, deputy chairperson of planning commission, was deemed as not an office of profit. That means a member of parliament can also be simultaneously deputy chairperson of planning commission. Despite being an office of profit, you cannot be disqualified. That was a law made by the parliament, has clearly and explicitly stated that this is not an office of profit. Similarly, the offices of chairperson of National Commission for Minorities, SCs and STs, for women, any legislator, even if they are appointed to these offices, they cannot be disqualified because these offices are deemed not an office of profit under the government of India. That means you can also be disqualified. Who can disqualify you? The President of India. But before disqualifying you, President has to refer this matter to Election Commission of India. Election Commission of India will conduct the investigation. Election Commission of India will decide whether your citizenship status has changed or not, whether you have turned mentally unstable or not, whether you have been declared a judge insolvent or not, whether you are holding office of profit or not. All these investigations will be carried out by Election Commission. Reports will be sent to the President. This report is binding on the President, and President has no other alternative but to remove you, disqualify you from being the member of parliament. And most importantly, is this office of profit. What is an office of profit? First, what is the background? To insulate members of the parliament so that their duties do not clash the interests. For that, this office of profit was created. Now, if you're holding this office of profit, you can be disqualified. How can you be disqualified? You can be disqualified if these 4 conditions are fulfilled. Whether you're holding an office, is this an office of profit? Is this an office of profit under the government of India or government of a state? If these are the 3 conditions which you are fulfilling, then you can be disqualified from your office. And the report of Election Commission of India is binding on the President. But there is something more to this office of profit, and we shall discuss it now. When I say that there are these 4 conditions which you will have to fulfill, that he held an office, that it was an office of profit, that it was an office under the government of India or a state government, that this office should be other than an office declared by the parliament by law, not to disqualify this holder. All these things are mentioned in a law passed by the parliament in 1959. And that law was Parliament Prevention of Disqualification Act 1959. This act was passed which prevented some of the offices from being declared as offices of profit. That means a legislator, even if he is holding these offices, and there's a big list of those offices, we don't want to remember that list, but there is a list. So these offices were placed in that list, and which even if a member of parliament is holding this office, he or she will not be disqualified because these offices have been exempted from being an office of profit. But when Jabachan was disqualified from being the member of Rajya Sabha because she was holding an office of profit, which was chairperson of UP Film Development Corporation, and suddenly newspaper reports came in. Year was 2006. It was suggested that there are at least 40 members of the parliament who should also be disqualified because they are also holding an office of profit. Speaker of Lok Sabha, Somnath Chatterjee, he was also holding the office of prophet. Curious case was that of Srimati Sonia Gandhi, who was a member of Lok Sabha, but at the same time, she was chairperson of National Advisory Council. National Advisory Council was given the status, the chairperson of National Advisory Council was given the status of a cabinet minister. The office was provided by the government. The benefits were provided by the government. A car was provided by the government. That means it was an office of prophet. Because some benefits, pecuniary gain, as Supreme Court said, was part of it. Ultimately, Parliament got together, and that 1959 law was amended, and in 2006, this law was amended, and many such offices were also added to that list. And ultimately, these offices were also declared as not holders of the office of prophet. That means we know more. What is an office of prophet? What is that the Supreme Court or the courts will have to look into while declaring that a particular office is an office of prophet or it is not an office of prophet? But another curious case is that of Guru Govinda Basu versus Shankar Prasad Ghoshal, 1964. Very briefly, I'm going to talk about this case so that it becomes absolutely clear to you what is an office of prophet. I'm explaining this topic because there is a dearth of knowledge available regarding office of prophet. Not many teachers and faculties explain it fully so that the students are also made to understand what exactly is this office of prophet. That's why I'm devoting a slightly longer amount of time in explaining this office of prophet. Guru Govinda Basu was a partner in a firm called G. Basu and Company. He contested the election and ultimately he won an election. This company was a private auditor company. It used to audit various companies. Ultimately, it was a private company. The government had not created this company. The government had not appointed G. Govinda Basu as a partner in this company. And ultimately, there was no chance of G. Basu being disqualified from being holding an office of prophet. But suddenly, a case was heard by the Supreme Court. Ultimately, G. Govinda Basu was disqualified from being a member of the parliament because he was holding an office of prophet. The court was asked, how can you justify the disqualification of Mr. G. Govinda Basu when he is not holding an office of prophet? The courts were presented with some details. These details were, Guru Govinda Basu contested the election to Lok Sabha and won. Yes, yes. He is a partner in a company called G. Basu and Company, right? Yes. It is a private audit company, yes, yes. But at the same time, this private audit company is auditing the account of Durgapur Projects Limited and Hindustan Steel. And both these are government companies. So a private auditor is appointed to audit the accounts of government company. Who appointed you? The government. That means it is an office of profit. And ultimately, G. Govinda Basu was disqualified for being holding an office of profit. That means this company was not a government company. The applicant in this case, G. Govinda Basu, was not appointed by the government. But this company was appointed by the government to audit the accounts of the government company. That means you are under the influence of the government. That means there is something what we call pecuniary gain. If there is a pecuniary gain, that means you are holding an office of profit and you are disqualified. That means in this case, the Supreme Court also made it absolutely clear that office of profit is something which is a very important part of our constitution. If any member of parliament is holding an office of profit, that means he comes under the influence of the executive. That means he is sacrificing his duty on the basis of his interest. Interest takes a forward seat and duty takes a backward seat. We have to prevent this. And if we find even an element of pecuniary gain in that office, which is accruable to a holder through the government, that means it is an office of profit and you should be disqualified from being holding the office of profit. So this was about office of profit. Apart from these disqualifications, a member of the parliament can also be disqualified on the grounds of double membership. That means you cannot be simultaneously a member of Rajya Sabha as well as Lok Sabha. You will have to vacate one seat. At the same time, you can be disqualified under anti-defection law. But this thing we will discuss in detail in the schedules because this is something that is talked about by 10th schedule. As of now, just remember that you can also be disqualified on the grounds of defection under anti-defection law. At the same time, a house, which can be either Lok Sabha or Rajya Sabha, a house can declare the seat of a member vacant if he is absent from all its meetings for a period of 60 days. But here the element is, if you have sought the permission of the speaker before or the presiding officer before, then you can even absent yourself for a period more than 60 days as well. But without permission, if you're not attending the meetings of the house for 60 days, you can also be disqualified from being member of the parliament. And at the same time, you can also resign. And this resignation can result in the vacancy. But here is something very important here. If a president submits his resignation to the vice president, it is binding on the vice president to accept that. If vice president submits his resignation to the president, it is binding on the president to accept it. If High Court judge or Supreme Court judge tenders their resignation, it is binding on the president to accept that resignation. But if a member of parliament is resigning from his office, is resigning from his membership, is resigning from the house, the speaker or chairman may or may not accept the resignation. That means the speaker has the power to say, I'm not accepting the resignation if the speaker is sure that this resignation is not voluntary and it is not being coerced. Only the voluntary resignations are to be accepted by the speaker. If the speaker feels that this individual has resigned and it was not a voluntary resignation, he may or may not accept that resignation. If the speaker finds that the individual has resigned but because of threat, because of coercion, the speaker may or may not accept this resignation. But in all the cases, the resignations are to be accepted by those who receive those resignations. This was about vacancies. Now let's talk about some of the important offices, both of Lok Sabha as well as Rajya Sabha. First up, let's talk about Speaker. Supreme Court in Kyoto Holohan versus Zachigo. Supreme Court in Kyoto Holohan versus Zachigo way back in 1993 said that Speaker is the symbol of propriety and impartiality. Now how is the Speaker elected. Now, Speaker is elected by the members of the Lok Sabha by means of simple majority. That means the members of the parliament vote, and in that vote, any candidate who gets a simple majority of votes, ultimately this candidate is chosen as the Speaker of the Lok Sabha. That is how the Speaker is elected. How is the Speaker removed? If Speaker is elected by simple majority, the Speaker is removed by effective majority. Right? So Speaker is the symbol of propriety and impartiality. She is elected by the members of the Lok Sabha by a simple majority, but she can be removed only by effective majority. Now let's talk about some of the important details regarding the Speaker. First up, the Speaker is the presiding officer of Lok Sabha. That means the entire business of Lok Sabha is conducted on the directions of the Speaker. She is the conscience keeper of the Lok Sabha. She interprets the rules of business and procedure. She is the sole authority to determine whether a bill is a money bill or not. What is a money bill? We'll talk about later. But whether a bill is a money bill or not, the certificate of Speaker of Lok Sabha is final in that case. That means she has the final authority to determine whether a bill is a money bill or not. The Speaker continues to remain in office of the Lok Sabha till the completion of the term of Lok Sabha, which is normally for 5 years. But even before the completion of this term, there can arise vacancy. For example, Speaker resigns. If Speaker resigns, she can submit her resignation to the Deputy Speaker, and the resignation is accepted, and this individual ceases to continue to remain as the Speaker of that House. So one is the case of resignation. Second, the Speaker also ceases to remain the Speaker if she is not now the member of Lok Sabha. If she has been disqualified as member of Lok Sabha, she also disqualifies, she also ceases to remain as the Speaker of the Lok Sabha. Speaker can also be removed. How the Speaker is removed? First, a 14-day notice is given. After the expiry of this 14-day notice, there is voting in Lok Sabha. If by effective majority the members are voting against the Speaker, that means the Speaker ceases to remain in the office, the Speaker is removed from her office. But it does not mean that the Speaker is removed from Lok Sabha. The Speaker is removed from her chair. She will still continue to remain the member of the Lok Sabha. In this case, two important points are required. One, if a bill is to be passed in Lok Sabha, there has to be voting on this bill. Suppose there are 300 people present in Parliament in Lok Sabha who are voting on this bill. 150 are voting in favor of this bill, 150 are voting against this bill. So there's a deadlock here. Now this bill cannot be passed. This bill can also not be rejected because we don't know which side is the majority, because both sides are having equal majority. 150 in favor, 150 against. In this case only, the Speaker has what we call casting vote. That means Speaker can either vote in favor of this bill or vote against this bill, just to remove this deadlock. That means when this bill is voted upon by the Parliament, Speaker does not vote in the first instance. Speaker only votes when there is a deadlock between the two. Just to remove this deadlock, the Speaker has a casting vote to play. But second point, when the Speaker is to be removed, in this case, someone else presides over the House, presides over the Lok Sabha. Speaker sits at one place in the Lok Sabha. In this case, when the motion for the removal of Speaker is voted upon in the Lok Sabha, the Speaker can vote in the first instance. That the Speaker is just like any other member of the Lok Sabha. In that case, in the first instance itself, the Speaker can vote, but not in case of a deadlock. That means Speaker is the symbol of propriety and impartiality. She is elected by simple majority, she is removed by effective majority. Why she does not vote in the first instance, she only has a casting vote to remove the deadlock. But if the motion for removal of the Speaker is voted upon in Lok Sabha, in the first instance, the Speaker has the power to vote. And if by effective majority the resolution is passed in the Lok Sabha, then the Speaker shall be removed from her office. There is also a provision which maintains the independence of the Speaker, and that is his conduct and his work cannot be discussed and criticized in the Lok Sabha. Only when the motion for her removal is pending, then you can discuss her conduct. But apart from that, you cannot criticize the conduct of the Speaker of Lok Sabha. The Speaker is the conscience of the Lok Sabha. The Speaker is the final interpreter of the rules of business and procedure of Lok Sabha, and the Speaker knows how to conduct the House. Apart from that, her conduct in the House cannot be inquired in any court of law. How she adjourns the session, how she conducts the business of the House, all these are the things that cannot be challenged in any court of law. That means the court of law cannot go into how the Speaker of the House is conducting the business of that particular House. That means this is something where the courts are barred from proceeding further. These are some of the important things which maintain the independence and impartiality of the Speaker. Apart from Speaker, there is a Deputy Speaker of Lok Sabha to assist the Speaker. And just like the Speaker, Deputy Speaker is also elected by the members of Lok Sabha by simple majority. And just like Speaker, the members of the Lok Sabha, if they vote by effective majority, Deputy Speaker can also be removed from his office. That means to assist Speaker, Deputy Speaker is there. Deputy Speaker can resign by submitting his resignation to the Speaker. Speaker can resign by submitting his resignation to the Deputy Speaker. That means both these individuals can resign by submitting their resignation to each other. But in this case, what is important is that if Speaker is present, the Speaker will preside over the Lok Sabha. If Speaker is not present, then Deputy Speaker will preside over Lok Sabha. What if neither Speaker is present, not Deputy Speaker is present? In that case, who will preside over Lok Sabha? In that case, there is a provision. Speaker nominates not more than 10 members from amongst the members of Lok Sabha, and these 10 members form part of what we call panel of chairpersons of Lok Sabha. That means what are we talking about? Speaker. We say Speaker is the most important office of Lok Sabha. The sole authority to conduct the proceedings of the House is vested with this office of the Speaker. If Speaker is present, he will preside over the function. If Speaker is absent, Deputy Speaker will preside over the functions of Lok Sabha. What if Speaker as well as Deputy Speaker are absent? There is a provision that as soon as the Speaker is elected, the Speaker also nominates 10 members from amongst the members of Lok Sabha to a panel of chairpersons. That means if Speaker is absent, Deputy Speaker is absent, then anyone from these 10 members can preside over the functions of Lok Sabha. In one instance, what if Speaker is absent, Deputy Speaker is absent, all these 10 members are also absent? In that case, the House can choose anyone to preside over the Lok Sabha. That means the House which is present at that point in time can choose any member from amongst themselves and appoint that individual to carry on and preside over the functions of Lok Sabha at that particular point of time. That means Speaker, in her absence, Deputy Speaker. In their absence, anyone from the panel of 10 chairpersons. If all of these individuals are absent, any member who is chosen by the House can preside over Lok Sabha. But this is only if Speaker and Deputy Speaker are absent. If Speaker and Deputy Speaker have resigned, if Speaker and Deputy Speaker both have died, if Speaker Speaker and Deputy Speaker both have been removed, then who will preside over Lok Sabha? In that case, anyone nominated by the President. In that case, President nominates some member who presides over the meetings of Lok Sabha. That means it is in this case only if the Speaker and Deputy Speaker are absent that these members come in. If Speaker and Deputy Speaker are not in office, that means they have been removed or they are dead, then in that case, any member nominated by the President can perform the functions of the presiding officer of Lok Sabha. One of the important points to remember regarding Speaker. The normal term of Lok Sabha is 5 years. Now, when the 5 years are over, the term of the Lok Sabha expires, then the term of all members of the Lok Sabha also expires, and they also cease to remain members of Lok Sabha. But the Speaker continues to remain in her post till the first meeting of the newly convened or elected Lok Sabha. That means this is what I'm talking about. The Speaker, unlike every other member of the Lok Sabha, she does not vacate her post. She continues to remain in the post of the Speaker till the first session of the newly constituted, newly elected Lok Sabha. That means, unlike others, she does not resign from her office. She continues to remain in office. Another important point. When the elections are over, the members are elected to Lok Sabha. Now these members are called upon to enter into Lok Sabha. But here is where the oath ceremony takes place. That means every member of the Lok Sabha is to be administered oath as well. Who administers this oath? President. Or someone else nominated by the President. So this President normally appoints somebody called Speaker Pro Tem or Pro Tem Speaker. These members, newly elected members of Lok Sabha, are to be administered oath. Who administers this oath? Pro Tem Speaker. Who is this Pro Tem Speaker? Nominated by the President. What is the qualification of this Pro Tem Speaker? He or she should be the most experienced legislator. Most experienced legislator, not in terms of age, but in terms of the parliamentary experience. So we saw in the previous Lok Sabha, Manik Rao Bhagat was appointed as the Pro Tem Speaker. In the current Lok Sabha, Kamal Nath, the Congress politician from Madhya Pradesh, was nominated by the President as the Pro Tem Speaker. So Pro Tem Speaker is a temporary office. Pro Tem Speaker is nominated by the President for one specific purpose. The purpose is to administer oath to the newly elected members of the Lok Sabha and to preside over the election of the Speaker of Lok Sabha. So as soon as the oath ceremony is complete, then quickly the elections take place to the office of the Speaker, and ultimately when office of Speaker is elected, Pro Tem Speaker ceases to remain in office. Another important point. Speaker of Lok Sabha is generally the political party which is the ruling, which is governing the country. And a convention has got developed over a period of time is that if Speaker is from a ruling party, Deputy Speaker is from the opposition, from an opposition political party. So we have Mr. Thambut Rai from AIADMK as the Deputy Speaker of the Lok Sabha, while Srimati Sumita Mahajan, who belongs to the ruling party, is the Speaker of the Lok Sabha. So Speaker from the ruling party, by convention, from the opposition political party, you get the Deputy Speaker. But this is not mentioned in the Constitution, not mentioned in any law made by the Parliament. This is just a practice, just a convention. The Speaker should be from the ruling party, Deputy Speaker from the opposition. These are two important offices under the Lok Sabha, Speaker and Deputy Speaker of Lok Sabha. Similarly, in Rajya Sabha, we have a presiding officer. Who is the presiding officer of the Rajya Sabha? The chairman of Rajya Sabha. Who is the chairman of Rajya Sabha? The Vice President of India. If Vice President of India is not present in Rajya Sabha, who is not presiding over the meetings of Rajya Sabha, in that case, Deputy Chairman of Rajya Sabha shall preside over the meetings of the particular house of Rajya Sabha. That means just like we have Speaker and Deputy Speaker in Lok Sabha, we also have Chairman and Deputy Chairman in Rajya Sabha. Chairman is the Vice President of India. Deputy Chairman is the presiding officer who presides over Rajya Sabha in absence of the Vice President of India. But this Deputy Chairman of Rajya Sabha is a member of Rajya Sabha. Unlike the Vice President, who is not a member of Rajya Sabha, Deputy Chairman is the member of the Rajya Sabha. Can Deputy Chairman resign? Yes, by submitting his resignation to the Chairman, and the Chairman shall have to accept that resignation. Deputy Chairman can also be removed from his office. Since Deputy Chairman is elected by simple majority, just like the Speaker and Deputy Speaker, he can also be removed by effective majority. Just like in Lok Sabha, we also have a panel of chairpersons in Rajya Sabha. Here the Chairman of Rajya Sabha nominates not more than 10 people from amongst its members as the members of the panel of chairperson of Rajya Sabha, and in absence of chairperson and vice chairperson or deputy chairperson, these members can preside over the functions of the Rajya Sabha. Similarly, we have the leader of the House in both Lok Sabha as well as Rajya Sabha. In Lok Sabha, normally it is the Prime Minister who is the leader of the House. If Prime Minister is the member of Lok Sabha, Prime Minister Modi is the leader of the House right now. But in the previous Lok Sabha session, and even before that, Prime Minister Manmohan Singh was not the leader of the House because he was not a member of Lok Sabha. In that case, sometimes it was Pranab Mukherjee who was leader of the House, or Sushil Kumar Shinde who was leader of the House. That means leader of the House either is the Prime Minister if he is the member of the Lok Sabha, or a senior minister of the government. We have a leader of House in Rajya Sabha also. It does not mean that leader of the largest political party in Rajya Sabha is the leader of the House. No. The leader of the government, that means the member of the ruling government, a senior minister of the government, is the leader of Rajya Sabha. That means he is the representative of the government. What are we talking about? Officers. We talked about Speaker, Deputy Speaker, Deputy Chairperson of Rajya Sabha. Now we are talking about leader of the House. In Lok Sabha, Prime Minister is the leader. If Prime Minister is not a member of Lok Sabha, then a senior most minister is the leader of the Lok Sabha, normally nominated by the Prime Minister. In case of Rajya Sabha, also we have leader of the House. But this leader of the House, just like today, Arun Jaitley is the leader of the House of Rajya Sabha, a senior minister in Rajya Sabha. But BJP is a minority in Rajya Sabha. So how can Arun Jaitley be the leader of the House of Rajya Sabha? Because Congress party, which is the largest political party in the Rajya Sabha, for Congress political party, there is another position, another office, and that is the office of leader of opposition, both in Lok Sabha as well as in Rajya Sabha. That means any political party which is not in government, if it gets 1/10 of the total strength of the House in terms of their seats, then that party can be allowed to nominate someone as the leader of the opposition. In Lok Sabha currently, BJP was the single largest party, more than 282 seats. The second largest party in terms of numbers was the Congress party, which would get only 44 seats. But 1/10 of 543 is not 44. That means no political party was in a position, was able to get 1/10 of the total seats of the Lok Sabha. That is why we do not have a leader of opposition in Lok Sabha. We have a leader of the largest party in Lok Sabha, which is Mr. Mallikarjun Kharge, who belongs to the Congress party, but he is not the leader of opposition. He is the leader of the largest opposition party in Lok Sabha. But in Rajya Sabha, Ghulam Nabi Azad of the Congress party, since Congress party has a strength of more than 1/10 of the total strength of Rajya Sabha, the Congress party nominated Ghulam Nabi Azad as the leader of opposition in Rajya Sabha. And he has some specific perks as well. Leader of opposition has been given a status of cabinet minister. That means they are entitled pertaining to salaries, allowances, and other functions or functionalities which are similar to a cabinet minister. This was about leader of opposition. We talked about some of the offices of Lok Sabha and Rajya Sabha: Speaker, Deputy Chairperson. We talked about leader of the House, leader of the opposition. There is also another office. That's what we call whip. This office is just like an assistant floor manager. That means every political party appoints an individual, a member of the parliament, as its whip. This whip is entrusted with the task to ensure that members of that particular political party are present in the House. If you have to vote whether in favor of a bill or against that bill, this direction must be given to the members of the political party by this whip. For example, Jyotiraditya Scindia of Congress. He is the chief whip of the Congress party. It is the task of Jyotiraditya Scindia to ensure that all members of the Congress party are present when they are required to be present. That means if voting is to take place for GST, whether they should vote in favor of the GST or against the GST, who will tell these members? The chief whip, Jyotiraditya Scindia. That means he's just like assistant floor manager of the party, which is nominated by the party to ensure the attendance of the members and also to regulate the conduct of the members of the parliament. And if you violate these whips, disciplinary actions can be taken against you. But that disciplinary action we are going to talk about in anti-defection law, which comes under 10th schedule of Indian Constitution. These were some of the important offices under Lok Sabha and Rajya Sabha.
In this session, let us talk about the various sessions of Indian Parliament. Constitution talks about that there shall be session of Parliament in such a manner that 6 months should not elapse between the first. Constitution talks about that there shall be session of Parliament in such a manner that 6 months should not elapse between Indian Parliament. Constitution talks about that there shall be session of Parliament in such a manner that 6 months should not elapse sessions of Indian Parliament. Constitution talks about that there shall be session of Parliament in such a manner that 6 months should not elapse between the first and the second session. That means the President of India shall have to convene the sessions of the Parliament in such a manner that the time frame between the first and the second session should not exceed 6 months. That means minimum there has to be 2 sessions of Indian Parliament convened by the President, because Constitution explicitly talks about that the time frame between the first and the second session should not be more than 6 months. So minimum we should have 2 sessions of Indian Parliament. But normally we have 3 sessions of Indian Parliament: the budget session, the first session of the Parliament, then we have the monsoon session, and then we have the winter session. If you look at the time frame, you will realize that budget session is the longest session of Parliament, and winter session is the shortest session of Indian Parliament. That means what are we talking about? We are talking about the sessions of Indian Parliament. How many sessions are there in Indian Parliament? Normally there shall be 2 sessions of Indian Parliament per year, because 6 months is the time frame here. But in practice, we have 3 sessions of Indian Parliament. Then we have also some other sessions of Indian Parliament, such as special sitting of Indian Parliament, and that we will discuss slightly later. But here, let's talk about some important concepts. Number 1, when the elections are over to Lok Sabha, then the new Lok Sabha is convened. What happens on the first day of this new Lok Sabha? The oath ceremony takes place. Who administers the oath? Pro tem speaker. Who is appointed as pro tem speaker? An individual who has the largest wealth of experience in Indian Parliament. Who appoints this pro tem speaker? The President of India. Now, when pro tem speaker is administering oath to various individuals who are represented in Lok Sabha, then we also see that the election of Lok Sabha speaker takes place. And when this election of Lok Sabha speaker takes place, then Lok Sabha speaker is elected, deputy speaker of Lok Sabha is elected, then also a panel of 10 chairpersons are nominated by the speaker of Lok Sabha. But here what happens? In this first session of Indian Parliament, there is joint address by the President. This happens at 2 places. First, the first session of newly constituted Lok Sabha after the elections. Lok Sabha members, Rajya Sabha members, together they sit and ultimately they are addressed by the President of India. Because President is an integral part of both executive as well as legislature. So President addresses both houses of Indian Parliament. That means it is also a joint session of Indian Parliament. That means the first session of newly constituted Lok Sabha, there is a presidential address. But not only after the elections to Lok Sabha does the President of India address both houses of the Parliament together. He also does that when there is a first sitting of the Parliament in a year. That means what are we talking about? Various sessions of Indian Parliament. How many minimum sessions should the President of India convene per year? 2. Because 6 months is an important time frame mentioned in the Constitution. Also, we talk about that as soon as the elections to Lok Sabha are over, newly constituted Lok Sabha comes together in association with the Rajya Sabha members. Both these members are together addressed by the President of India. This is what we call presidential address. But not only after elections. We also see that the first day of the first session of Parliament in a year, that means budget session. On the first day of this budget session, the President of India addresses both houses of the Parliament together. This is what we call presidential address. The text of this presidential address is written by Council of Ministers. That means normally by the government. That means government presents a speech and gives it to the President of India. Their President of India, please deliver this speech to the joint session of Indian Parliament. What is mentioned in this speech? In this speech it is mentioned that what are going to be the policies of my government in the next year? What are going to be the economic challenges, political challenges? How are we going to tackle those challenges? That means the agenda of the government for that particular year is set out clearly in this presidential address by the President of India. And who provides the text of the speech of the President? It is the government, it is the Council of Ministers. Now, after this presidential address is over, then Lok Sabha sits in Lok Sabha, Rajya Sabha members sit in Rajya Sabha, and then there is motion of thanks on this presidential address. That means after the presidential address is over, Lok Sabha members sit in Lok Sabha, Rajya Sabha members sit in Rajya Sabha, then there is a discussion, there is a debate on this presidential address. The text of this presidential address is dissected both by the government as well as the opposition. Normally, the government praises the presidential address. This is the best speech that we have witnessed. The opposition members criticize this presidential address. Normally, there is no mention of terrorism, for example. There is no mention of black money. That means you are criticizing. The opposition is criticizing the agenda of the government of India for that particular year. After this motion of thanks is over, there is a vote. That means on this presidential address, voting takes place. If this vote is passed by simple majority, the presidential address is passed. If this vote is not passed by simple majority, then what does that mean? The Council of Ministers shall have to resign. That means what are we talking about? After this presidential address is over, there's a motion of thanks on this presidential address, followed by the vote. If this vote is passed by the simple majority, the presidential address is passed. If this vote is defeated in Lok Sabha, it involves censure of Council of Ministers. And when it involves censure of Council of Ministers, that means the government cannot take any policy decisions. That means prima facie, the government has lost majority in Lok Sabha. Then what is it that they have to do? They have to immediately seek vote of confidence in Lok Sabha. If that vote of confidence is also defeated, ultimately the government will have to resign. That means what are we talking about? Session of Indian Parliament, presidential address. Followed by the presidential address, we have motion of thanks. And motion of thanks is followed by the vote in both Lok Sabha as well as Rajya Sabha. If
this motion of thanks on the presidential address is defeated in Lok Sabha, it involves censure of the House. When it involves censure of the House, that means the Council of Ministers, the government cannot take any policy decision. It involves absolute censure of Council of Ministers. That means prima facie, the government has lost majority in Lok Sabha. Then immediately the government will have to seek vote of confidence in Lok Sabha. If that vote of confidence is won by the government of India, is won by the party in power, ultimately the government survives. If this vote of confidence is lost in Lok Sabha, is defeated in Lok Sabha, ultimately the government will have no other option but to resign. But what happens if this vote is defeated in Rajya Sabha? Voting takes place in Lok Sabha. If it is defeated in Lok Sabha, it involves censure. Then government has to seek vote of confidence again. But if this motion of thanks on presidential address is defeated in Rajya Sabha, then what will happen? Nothing will happen. Why nothing will happen? Because Council of Ministers are collectively responsible to Lok Sabha. Whether they remain in office or not will be determined by the fact whether they command majority in Lok Sabha or not. That means the government has only to convince Lok Sabha that yes, we are the party in power, we command majority in Lok Sabha. In Rajya Sabha, if this presidential address is defeated, nothing will happen. But in Rajya Sabha, something else can happen. What is it? That this presidential address can be amended. How? We have seen that in an era of coalition politics, where no party is able to command the majority on its own, what results? It results in a coalition government. Various parties come together and form the government. But we also see, in the last 30 years, we have seen that government, although it is in majority, or the ruling coalition is in majority in Lok Sabha, but in Rajya Sabha, the position is completely different. In Rajya Sabha, it is the opposition which has an upper hand over the government. And this presidential address is sometimes amended in Rajya Sabha. And this has happened 5 times in the past. And most importantly, it has happened twice under the Narendra Modi-led BJP government at the same time. That means last year, when the President of India, Pranab Mukherjee, addressed joint session of Indian Parliament, Lok Sabha as well as Rajya Sabha, in the first sitting of the budget session, he talked about various policies of the government of India. He talked about various adventures of the government of India. He talked about various opportunities that the government is going to give to the youth of this country. At the same time, in Rajya Sabha, this presidential address was amended. The amendment talked about that we regret the president did not speak about the black money. So this amendment was added to the presidential address. Ultimately, when this amendment was added to the presidential address, this presidential address was passed. But most importantly, what we are talking about? We are talking about that this presidential address is primarily talking about the objectives, the policies of the government, because the text of this address is provided by the government itself. Now, if this address is defeated in Lok Sabha, it involves censure. If it is defeated in Rajya Sabha, nothing will happen, because Council of Ministers are accountable to Lok Sabha. But at the same time, we see that this presidential address can be amended. It may not be amended in Lok Sabha because government is a majority there, but it may be amended in Rajya Sabha because in Rajya Sabha, the government does not command majority of its own. And in that case, we have seen 5 times in the past, this presidential address has been amended. Now, this was about the presidential address. After delivering his speech, the president goes back to Rashtrapati Bhavan, and then there is a debate in the parliament. When there is a debate in the parliament, there are various options available. The first option is adjournment. What do we mean by adjournment? Brief interval in an ongoing session. The session is going on, budget session, monsoon session, winter session, any session. The session is going on. Then when the session is being carried out, there can be various adjournments. What is this adjournment? A brief interval in an ongoing session. Who has the power to adjourn the House? Whether Lok Sabha or Rajya Sabha? The power is vested with the presiding officer. That means what are we talking about? We are talking about that sessions of Indian Parliament are very important from the examination point of view. Who convenes the session of Indian Parliament? President of India. On whose advice? Only on the advice of Council of Ministers. That means the Council of Ministers advise the President of India, please convene the session of Indian Parliament. It is binding on the President of India to convene the session of Indian Parliament. Now the session has been convened. Let us assume for a while that this is a budget session. Now ultimately what will happen? The business of the House will be carried out, the bills will be taken up, debates will be conducted, questions will be asked to ministers. There are various agendas that the Lok Sabha and Rajya Sabha will have to pursue while the session is going on. But the convening of the session, the power rests with the President of India. But there can be various adjournments. But the power to adjourn the House is vested with the presiding officer. Chairman in case of Rajya Sabha, Speaker in case of Lok Sabha, or anyone who acts as the presiding officer of that House. Now in this case what happens? For example, the session is going on, but there is a ruckus in the Parliament. The members of the Parliament are screaming at the top of their voices. They are lifting the chairs and throwing it at each other. Ultimately, the business of the House, the agenda of the House cannot be carried out in such an atmosphere. That means there is no decorum in the House. When you are not hearing each other because there is pandemonium in the House, there is a ruckus in the House, then Speaker has no other option but to adjourn the House. That means we are adjourning the House, we are briefly halting the session. But this adjournment is of 2 types. Adjournment with date and time specified. The Speaker of the House will say, the House is adjourned and we are going to meet tomorrow, 10th of January, 12 p.m. in the afternoon. That means the Speaker is adjourning the House. That means she is halting the ongoing session. There's an interval in the ongoing session, but at the same time, the Speaker is explicitly mentioning the date and time on which this Lok Sabha or Rajya Sabha is to be convened again. That means adjournment with date and time specified. There's also another type of adjournment, and that is what we call adjournment sine die. The Speaker or the presiding officer of Lok Sabha and Rajya Sabha will say, the House is adjourned sine die. That means the Speaker is not mentioning the date and time on which the House is going to be convened again. Normally, when does this happen? We talked about when there is a ruckus in the House, when there is pandemonium in the House. Ultimately, the agenda of the House cannot be carried out. When the agenda of the House cannot be carried out, the Speaker or the presiding officer provides an opportunity. Let's adjourn this House for a while and see if we come back to this House after 20 minutes or half an hour or 1 hour. Will the situation subside or will they continue with this ruckus? When the House is convened again, same ruckus is going on, she adjourns the House again. Let's meet tomorrow. If there is no ruckus in the House, then ultimately what will happen? The agenda of the House will be carried out. But what about adjournment sine die? In this adjournment sine die, what will happen? The Speaker or the presiding officer does not specify the date and time of the convening of the next sitting of Lok Sabha or Rajya Sabha. Why? Because the power to adjourn the House rests with the Speaker, but the power to convene the House rests with the President of India. The power to terminate the session of Indian Parliament also rests with the President. That means presiding officer cannot terminate a session. She can only adjourn a session. An adjournment can be with date and time specified, or adjournment can be sine die. When does the sine die come into picture? For example, from November to December, there is winter session of Indian Parliament. Today, it is the last day of the winter session of Indian Parliament. The Speaker of the House adjourns the House. She says that the House is adjourned sine die. Because the session is ended, there is no other legislative business in order. The session was convened from 1st November, for example, till 16th December. From 1st November to 16th December, the power rests with the Speaker or presiding officer to adjourn the House. And what is this adjournment? Brief interval in an ongoing session. That means adjournment does not terminate a session. It is only a brief interval in an ongoing session. But let us assume for a while that we are in 16th of December 2017, for example. Today is 16th December 2017. Now what will happen? The Speaker will adjourn the House sine die. Because now the session is ended. But she cannot end the session. Who can end the session? President. Ultimately, the Speaker cannot end the session. She only says that the House is adjourned sine die. When the House is adjourned sine die, it paves way for the President of India to prorogue a session. And what is prorogation? Prorogation is the formal termination of an ongoing session. And who can prorogue the House of the Parliament? The power is vested with the President. Can President of India do this on his own? No. Under Article 85, Clause 2 of Indian Constitution, the power is vested with the President of India to terminate a session. to prorogue a session, but only on the advice of Council of Ministers. That means just like the President of India can convene the session of Indian Parliament only on the advice of Council of Ministers, it is only on the advice of Council of Ministers that what will happen? The session of Indian Parliament can be terminated. The session of Indian Parliament can end. Now, important point to note here. Adjournment, prorogation. For example, there are various agendas pending in the Parliament. Let us take the case of Lok Sabha. For example, in Lok Sabha, there is a motion pending for the removal of Deputy Speaker. Clear? Or for that matter, there is a bill pending. Let us assume it is a surrogacy bill. Or for that matter, there is a resolution pending that let us declare Pakistan as a terrorist state. Now, for example, these three agendas are pending in the Lok Sabha. Then what will happen? The Speaker of the Lok Sabha will adjourn the House. What will happen to this motion? What will happen to this bill? What will happen to this resolution? Nothing will happen. These motions, these resolutions, these bills will continue to have the life of their own. That means they will not lapse because it's only adjournment. What adjournment does? It's only a brief interval in an ongoing session. Whether it is adjournment with date and time specified or whether it is adjournment sine die, nothing will happen to any motion pending in the Lok Sabha, any resolution pending in the Lok Sabha, any bill pending in the Lok Sabha. But as soon as the session is prorogued by the President of India, what will happen? Motions will lapse. What will happen? These resolutions will lapse. But what will happen to these bills? These bills will continue to have the life of their own. That means these bills will not lapse. That means what are we talking about? Just to recapitulate, we are talking about sessions of Indian Parliament. How many sessions can be there? Minimum 2 sessions. 6 months. Minimum 2 sessions of Indian Parliament. But we have 3 sessions normally. Budget session, monsoon session, winter session. Now, convening of the session, President convenes the sessions of Indian Parliament. Who can adjourn the House? Speaker, the presiding officer. Who can prorogue the House? The President of India. And that too, only on the advice of Council of Ministers. Now, if the House has been adjourned, or if the House has been prorogued, what will happen to these bills, motions, resolutions? If it is adjournment, nothing will happen. But if it is prorogation, which is the termination of a session, which is the end of the session, which is the date of the session, motions, resolutions will lapse, but bills will continue to have the life of their own. But not just adjournment, not just prorogation. There's a third important concept here. That is what we call dissolution. That means the House can be dissolved. Now, which House can be dissolved? Not Rajya Sabha, because Rajya Sabha is the permanent House of Indian Parliament, but Lok Sabha can be dissolved. How does this happen? First is automatic dissolution. That means the normal life of Lok Sabha, the normal term of Lok Sabha is 5 years. The 5 years are over, there is automatic dissolution of Lok Sabha by the President of India. Now, that means the newly constituted Lok Sabha will be in operation, the old Lok Sabha is dissolved. Why dissolved? Because 5-year term, which is the normal term of Lok Sabha, that is expired. When the term is expired, the new Lok Sabha has to be convened. Not only after the term is over, the normal term of 5 years is over, but even before that, even prior to the 5-year normal term of Lok Sabha, this Lok Sabha can be dissolved. Who can dissolve this? President. Can President do this on his own? No. He can do this only on the advice of Prime Minister. This is where your book, Lakshmikant, is slightly wrong. Dissolution of Lok Sabha does not take place on the advice of the Council of Ministers. It takes place only on the advice of Prime Minister. Now, this Prime Minister may discuss this dissolution with his colleagues, but he is not bound to take this matter before the Cabinet. That means he is not under any obligation to take this matter before the Cabinet or his Council of Ministers. If on his own, the Prime Minister of India, Mr. Narendra Modi, is recommending to the President of India that please dissolve Lok Sabha, it is binding on the President of India to dissolve the Lok Sabha. That means we have seen. In 1970s, when Indira Gandhi liberated Bangladesh, she was considered as the Durga of India. That is a very powerful Prime Minister. Now, after the liberation of Bangladesh, after food security mechanism, which you will read in your post-independent India, she decided, let's reap the benefits of my good policies. Recommended to the President that let's prematurely dissolve Lok Sabha. The term of the Lok Sabha was not over. There was still some time for the Lok Sabha to expire. But Prime Minister recommended to the President, dissolve the Lok Sabha so that there are fresh elections. And in these fresh elections, I'm going to be elected with an overwhelming majority. But leave politics aside. We're talking about 3 instruments. Adjournment, prorogation, that I think has been explained. But what about dissolution? Dissolution dissolves the Lok Sabha. Who has the power to dissolve the Lok Sabha? The President. And that too only on the advice of the Prime Minister of India. Now, we have seen with adjournment, nothing happens to the bills, nothing happens to the motions, nothing happens to the resolutions. We will discuss later what do we exactly mean by motion, what do we mean by resolution. But here, in prorogation, the bills do not lapse, but the motions and resolutions lapse. In case of dissolution, motions lapse, resolutions lapse, notices lapse, every damn business in the Lok Sabha lapses, every bill which is pending in the Lok Sabha also lapses. That means every category of the bill lapses except 3 types of bills. These 3 types of the bills do not lapse. Apart from these 3 types of bills, every other category and type of the bill lapses upon the dissolution of Lok Sabha. Which are these types of the bills? Let's talk about that. Number 1, a bill which is originating in Rajya Sabha and pending in Lok Sabha. Now, when I talk about 3 important types of the bills that do not lapse, the first type is a bill which is originating in Rajya Sabha and is pending in Rajya Sabha. This bill does not lapse. But for example, a bill has been passed by Lok Sabha, but it has been sent to Rajya Sabha. What will happen to this bill? This bill will also lapse. Why? Because Rajya Sabha will have the option to send this bill back to Lok Sabha for reconsideration, but there is no Lok Sabha, so this bill also lapses. That means a bill which is pending in Lok Sabha, whether it has originated in Lok Sabha or whether it has originated in Rajya Sabha, if this bill is pending in Lok Sabha, this bill will lapse. But if there is a bill which is originated in Rajya Sabha as well as pending in Rajya Sabha, this bill does not lapse. Similarly, we have seen that this particular bill shall have to be passed by both houses of the Parliament. Now, for example, Lok Sabha passes a bill, Rajya Sabha does not agree with that bill. Now, what will happen? There will be a deadlock. To resolve this deadlock, what is the provision in Indian Constitution? The President of India shall convene the joint session of Indian Parliament. If a bill for which a joint session of Indian Parliament has been convened by the President of India, this bill also will not lapse. That is the second type of bill, a bill not passed by the 2 houses due to disagreements, and if the President has notified the holding of joint sitting before the dissolution of Lok Sabha, shall not lapse. That means what will happen? A bill originating in Rajya Sabha and pending in Rajya Sabha will not lapse. A bill on which there are disagreements. There are disagreements to resolve this deadlock. Joint session of Indian Parliament has been notified by the President. After this notification, the Lok Sabha has been dissolved. Now, whether this bill is pending, wherever it is pending, we don't care about that. But since joint session of Indian Parliament has been notified by the President of India before dissolving the Lok Sabha, this bill also will not lapse. Third category, a bill which is waiting for the presidential assent. That means what are we talking about? A bill is passed by Lok Sabha, bill is passed by Rajya Sabha. Now, when this bill is to be sent to the President of India, he may sign it, he may not sign it. That means if there is a bill which is passed by both houses of the Parliament, but it is waiting for the presidential assent, this bill also will not lapse. That means these are the 3 categories of the bills which do not lapse upon the dissolution of Lok Sabha. Apart from these 3, every other category of the bill lapses. But when we talk about this third category, a bill which is waiting for the presidential assent, it may also result that this bill was sent to the President of India for his signature, but the President of India is returning this bill for reconsideration. He can do that. Suspensive veto, as we talked about, he can do that. He can retransmit this bill to Rajya Sabha. That means this bill has been sent back by the President of India to Rajya Sabha. Even this bill will not lapse. But this is a flavor of the third type. Adjournment, brief interval in an ongoing session. Prorogation, termination of the session. Dissolution of the Lok Sabha. Who has the power to convene the session? President. Who has the power to adjourn the session? Presiding officer. Who has the power to prorogue the House? President of India. Who has the power to dissolve the House? President of India. What happens upon the dissolution? bills, motions, resolutions, notices, everything lapses. And everything lapses except three categories of the bills. What are these three categories of the bills? Number one, bill which is originated in Rajya Sabha and pending in Rajya Sabha will not lapse. Second, a bill on which there is disagreement. How to resolve this disagreement? Call a joint session of Indian Parliament. Now, if the President has notified joint session of Indian Parliament just before the dissolution of Lok Sabha, this bill also will not lapse. Third, bill has been passed, but it is waiting for the presidential assent. President may sign this bill, President may return this bill. But whatever he may do, whether he will sign that bill or he will return that bill for reconsideration, this bill also will not lapse. Apart from that, every other category of the bill lapses. This was about the sessions of Indian Parliament, adjournment, prorogation, and dissolution. Now let us talk about the most fascinating concept in Indian Constitution: powers, privileges of the Parliament and the members thereof. Let's have a look at that. There are some powers, there are some privileges, there are some immunities which are vested with the members of the Parliament and Parliament as a whole. But why? And how? That's the important point. To enable the members of the Parliament to function without any threat, without any coercion, the Constitution talks about that there shall be some powers and privileges available to the members of the Parliament. What are these privileges? Constitution of India, under Article 105, talk about something very important. Constitution said that there has to be a law, and this law shall regulate these powers, privileges, and immunities. That means there has to be a law which can regulate these powers, privileges, and immunities which are available to the members of the Parliament. That means this law of the Indian Parliament is going to decide what are going to be these privileges, what are going to be these powers, what are going to be these immunities. Till the time Parliament frames a law to regulate all these things, whatever powers, whatever privileges, whatever immunities are available to the British parliamentarians, those same privileges will be available to the members of Indian Parliament as well. That means what are we talking about? There are some powers, privileges, and immunities which are available not only to the members of the Parliament individually, but Parliament as a whole as well. What are these powers, privileges, and immunities? Constitution said a law should be framed by the Parliament which should regulate these powers, privileges, and immunities. Unless and until there is a law framed by the Parliament, the same privileges, the same powers, the same immunities which are available to the British parliamentarians, since we follow British parliamentary structure, the same powers and immunities which are available to British parliamentarians, same powers, privileges, immunities shall also be available to Indian parliamentarians as well. Ultimately, what happened? 44th Constitutional Amendment Act, 1978. This law came into effect on 20th June, 1979. Why am I mentioning this date? I'll tell you. 44th Amendment of the Indian Constitution was done in 1978. The Parliament decided what is the reason, what is the rationale to refer to British Parliament? We are a sovereign country. Why should we say that powers, privileges, immunities of the members of the Parliament will be same as that of the British parliamentarians? This reference to British Parliament is to be deleted. And this reference to British Parliament was deleted by 44th Constitutional Amendment Act 1978. But then what are going to be these powers, privileges, immunities? This amendment Act talked about that the powers and privileges and immunities of the members of the Parliament will be the same as they existed on 20th June 1979. What were these powers, privileges, immunities of the members of the Parliament on 20th June 1979? The same powers which were available to British parliamentarians. Same powers, same privileges, same immunities will continue. The only thing that this 44th Amendment has done, it has deleted the reference to British Parliament. Nothing else. That means the same powers which are available to British parliamentarians, same powers, immunities, privileges are available to Indian parliamentarians as well, except the fact that this reference to Britain has been deleted by the Constitution. So that is the position. But when we are talking about this position, then how can we define which are the immunities, which are the powers, which are the privileges available to Indian parliamentarians? Let's talk about that. Constitution, under Article 105, explicitly talks about two freedoms or two powers. One is freedom of speech and freedom of publication. That means whatever is happening in Indian Parliament, whether it is a discussion on a bill, whether it is a resolution, whether it is debate that is going on in the Parliament, whether there are some disagreements in the Parliament, all these things can be discussed, all these things can be reduced into writing, and these things can be published. This is the power available to the Parliament as a whole. That means Constitution under Article 105 talks about one, right of publication. That means it is the power of the Parliament to publish its own debates, motions, resolutions, bills, discussions, everything that is the power available to the Parliament. But at the same time, there shall be freedom of speech. What is this freedom of speech? Don't confuse this freedom of speech with freedom of speech and expression under Article 19, Clause 1, Clause A. In Article 19, Clause 1, Clause A, you have freedom of speech and expression, yes, but this freedom of speech and expression is not absolute. It comes under reasonable restrictions, and we have discussed those reasonable restrictions. That means we are talking about something very important. Freedom of speech which is available to the parliamentarians is absolute. When we say absolute, that means whatever they say in the Parliament, whatever vote that they give in the Parliament, they cannot be liable for their actions before any court of law. That means they have absolute freedom of speech in the Parliament. Why is this freedom of speech available to the parliamentarians? Absolute. It is absolute primarily because of the fact that it is absolute in case of Britain. Why absolute? because in order to enable the members of the parliament to freely express their opinions, to freely represent the views, the aspirations, and the sentiments of their constituency, it is for this reason that this freedom of speech is made available to the members of the parliament. But something curious also happens. Something curious, let's talk about that, something very, very curious. And that is one of the most shocking cases in the history of independent India, JMM bribery case. What happened in this case? But first, let me take you back to something very important. No person shall be liable, that means no member of the parliament shall be liable in respect of anything said or any vote given by him in the parliament. That means you cannot be held accountable for whatever you say in the parliament and whatever vote you give in the parliament. Come back to 1993. P.V. Narasimha Rao was the Prime Minister. Now suddenly what happened? P.V. Narasimha Rao realized that I am not commanding majority in Lok Sabha. The government was a minority government. That means it was not commanding absolute majority in the Lok Sabha. Suddenly what happened? A vote of no confidence was moved against Prime Minister Narasimha Rao. If this vote of no confidence was passed in the Lok Sabha, what would have happened? If this vote of no confidence is passed in Lok Sabha, P.V. Narasimha Rao would have no other option but to resign. So what he did? Some people say he bribed the members of the parliament. Some members from the Janata Dal, some members from Jharkhand Mukti Morcha. But curious is the case of 5 MPs. Let me divide it into 4 MPs on one side, 1 MP on the other side. And look at this very beautifully and very carefully. Powers, privileges, immunities of the members of the parliament. Same immunities that are available to British parliamentarians, same immunities are available to the Indian parliamentarians also. What are these immunities? Number 1, freedom of speech. No member of the parliament can be held liable in any court of law for whatever he has said in the parliament and any vote he has given in the parliament. What happened? Narasimha Rao government thought that we will lose majority in Lok Sabha, and some people say that Narasimha Rao government bribed the members of the parliament who were not on their side. When the members of the parliament were bribed, ultimately voting took place, and ultimately the government survived because that motion of no confidence was defeated in Lok Sabha. When it was defeated in the Lok Sabha, then many people raised their eyebrows. How is it that P.V. Narasimha Rao survived? Because he does not have majority in Lok Sabha. That means he might well have bribed the members of the parliament. If he has bribed the members of the parliament, there should be investigation. And CBI conducted the investigation. Central Bureau of Investigation versus Narasimha Rao. Ultimately, when investigations were carried out, it became absolutely clear that yes, bribes were given. It became absolutely clear that Janata Dal members were also given bribe. Jharkhand Mukti Morcha, JMM, these members were also given the bribe. But curious was the case of these 5 MPs. These 5 MPs were given bribe, were provided bribe by whoever we don't know, but they were provided bribes. They were given bribes. Out of these 5 MPs, 4 members who were paid bribes, they voted. They voted to defeat this no confidence motion. But this one MP suddenly realized his conscience. Although he was paid the bribe, but he said, I'm not going to vote. Because suddenly his conscience woke up. Ultimately, these 4 members who voted, and this one MP, although he was paid the bribe, he did not vote. When the investigation took place, the matter went to the court. The court said, 2 questions are important. Question number 1, are these MPs, the members of the parliament, public servants? Why? If they are public servants, that means Prevention of Corruption Act 1986 will apply on them. If Prevention of Corruption Act 1986 shall apply on them, that means bribe giving and bribe taking is offense and they can be prosecuted. The court said yes, they are public servants. When they are public servants, question number 2, is bribe allowed? Is bribe allowed inside the parliament? The court said these 4 MPs who were paid the bribes and who voted to defeat this motion of no confidence, don't prosecute them. But this one MP who was paid the bribe but who did not vote, prosecute him. Why prosecute him? Look at Article 105 again. No member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given. The Supreme Court said there has to be a nexus between bribe and voting. If you are paying the bribe, for what? To vote. But if you are voting, you cannot be held accountable to any court of law. Why? Because there is absolute freedom of speech available to you. That means you cannot be held liable for any vote that you give in the parliament. That means the bribe was given. But why was bribe given? To vote in one way or the other. For that, the Supreme Court cannot prosecute these individuals. But in this case, in the case of one MP, bribe was given. Bribe was given, but he did not vote. So there is no nexus between bribe and voting. Prosecute this individual. That means this was a very, very notorious verdict given by the Supreme Court in 1998 in CBI versus Narasimha Rao. Ultimately, it was a plain reading of the Constitution. Constitution talks about that no person shall be held accountable who is a member of parliament. No member of parliament shall be held accountable for whatever they say in the parliament and any vote that they give in the parliament. These 4 MPs were paid bribes. But why? To vote in one way or the other. Don't prosecute them. Because there is a nexus between bribe giving and voting. But this individual, one MP, he was paid the bribe, yes, but he did not vote. So there is no nexus between bribery and voting. Prosecute this individual. Ultimately, this notorious judgment has been criticized very heavily by every constitutional expert, but this is the sad reality. That means the members of the parliament have absolute freedom of speech. They can say anything that they want to say in the parliament, and at the same time, they can vote in whichever manner they want to vote, even to the extent of taking bribes for that voting, and they cannot be prosecuted because there has to be a nexus between bribery and voting. But also, it does not mean that there is no restriction to this freedom of speech which is available to the parliamentarians. There is a restriction. Restriction number 1, you cannot criticize the conduct of the Speaker of the Lok Sabha. Restriction number 2, you cannot criticize the Supreme Court judges, except if a motion for their removal is pending in the parliament. That means you cannot suddenly criticize a judge. You cannot suddenly talk against a Supreme Court judge in the parliament. Only if you are debating the removal of the judge of the Supreme Court or the High Court, you can criticize that particular judge. But if there is no motion for the removal of the judge of the High Court or the Supreme Court pending in the parliament, you have no freedom of speech to criticize that particular judge. And also, you cannot use unparliamentary language. This is what we see sometimes in the parliament. If you have witnessed parliamentary debates, you will understand that sometimes the members of the parliament, they get up from their seats, ultimately request the presiding officer, please expunge these remarks. For example, in the last Lok Sabha, L.K. Advani gave a speech. L.K. Advani said, because of serious corruption charges, 2G scam, Commonwealth Games scam, coal scam, other scam, because of all these scams, there is no legitimacy in the Manmohan Singh government. That means Manmohan Singh government is illegitimate. Sonia Gandhi was furious. Other Congress members were furious. How can you declare this legitimately elected government by the people as illegitimate? Ultimately, they requested the speaker, please expunge, please delete these remarks from the speech of L.K. Advani. And ultimately, these remarks were expunged. That means yes, you have freedom of speech, but at the same time, this freedom of speech does not entail the freedom to use unparliamentary language in the parliament. So this was about one freedom of speech, which is available to the members of the parliament. Let's look at something else. We will divide these privileges into two categories: collective privileges and individual privileges. Collective privileges means the privileges which are available to the temple of democracy, which is parliament as a whole. Individual privileges, the privileges which are available to an individual member of the parliament. Let's talk about collective privileges. Collective privileges, number one, it can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. That means you see these parliamentary debates on Lok Sabha TV and Rajya Sabha TV. There are some dignitaries, there are some visitors who are present in the galleries of Lok Sabha and Rajya Sabha, because they also witness how the members of the parliament are performing their activities, performing their duties, performing their tasks. But it is a privilege, it is the power available to the parliament that they can exclude strangers from witnessing these parliamentary proceedings. That means sometimes when there is a matter of urgent importance discussed by the parliament, for example, let us say a Kashmir issue is discussed in the parliament. For example, the surgical strikes on Pakistan, how we conducted those strikes are to be discussed in the parliament. These are very sensitive matters. These matters deal with national importance. These matters deal with national security. These matters deal with sovereignty, territorial integrity of the nation. Ultimately, if something secret is to be discussed by the members of parliament as a whole has a privilege to exclude strangers from witnessing these proceedings. Collective privilege. Number two, it can punish members as well as outsiders for contempt. For example, Lalu Prasad Yadav heavily criticized LK Advani. He told LK Advani that you are aspiring to become the prime minister, but your wish will never be fulfilled. That means inside parliament, we criticize heavily each other. BJP members will criticize Congress, Congress members will criticize Trinamool Congress, Trinamool Congress members will criticize left parties. Ultimately, they are always criticizing each other. But if they're criticizing each other, that is okay. But if an outsider criticizes the parliament as a whole, everybody comes together. For example, Anna Hazare. Anna Hazare, Arvind Kejriwal in India against corruption movement. They said that Indian parliament is filled by rapists, murderers, and corrupt people. Lalu Prasad Yadav, LK Advani, Sonia Gandhi, Prakash Karat, Mamata Banerjee, everybody came together, passed a resolution criticizing Anna Hazare and Arvind Kejriwal. That means the parliament as a whole has the power to punish members for contempt. That means they can impose a fine on outsiders. They can get outsiders imprisoned for contempt proceedings against parliament. That means one collective privilege is that you can exclude strangers from your proceedings. Second collective privilege is that you can punish its own members as well as members from outside for contempt. At the same time, the courts are prohibited to inquire into the proceedings of a house or its committees. The court cannot say, why have you taken GST bill for discussion? Why have you not taken citizenship amendment bill for discussion? Why is it that question hour begins from this date? Why is it that question hour begins from this time to this time? Why was there no 0 hour today? Why was this bill not taken up? The courts are not allowed, the courts do not have the power to inquire into the proceedings of a house or in committee for that matter, in committee of Indian parliament. The courts are barred from going into that. Collective privilege. No person, either a member of the parliament or an outsider, can be arrested, and no legal process, civil or criminal, can be served within the presence of the house without the permission of the presiding officer. That means a member of the parliament is to be arrested. Arrested, yes, but first seek the permission of the presiding officer, the speaker of the house. Without his permission, you cannot arrest this member of the parliament. So suddenly, I'm not a member of parliament, but I'm present in the gallery and I'm witnessing the proceedings of Lok Sabha. Suddenly, an arrest warrant is issued against me. This arrest warrant cannot be served on me because I'm present in the parliament without the permission, without the acceptance of the presiding officer of the house. That means only when the presiding officer will allow, ultimately you, that means the police party, can arrest me from within the presence of the parliament. These are some of the important collective privileges which are available to the temple of democracy as a whole. What about individual privileges? Let us talk about them. Now, let's talk about these individual privileges. Individual privilege number one, freedom from arrest. What does that mean? For example, this is the session of Indian parliament. Let us say this is the monsoon session. If monsoon session is going on, I am a member of the parliament, I cannot be arrested. Not only during the session of Indian parliament, even 40 days prior to the beginning of the session and 40 days after the session has ended. That means in this time frame, no member of the parliament can be arrested. What is the rationale? The rationale is that this is the picture which is present in Britain as well. In Britain, the lawmakers made a clear agenda. They said the job of a parliamentarian is very, very important. And the job of this parliamentarian is to legislate, to make laws for the betterment of the people of this country. So this task is very important. That means 40 days prior to the beginning of the session, when the member of the parliament shall have to prepare his laws, shall have to prepare his questions, shall have to prepare his debate in the parliament, he should not be arrested. And 40 days after the session is over, to see how the session has helped the people of this country, to analyze the session of Indian parliament. Even 40 days after the session of Indian parliament, this member of parliament also cannot be arrested. But this is the provision. This is the protection available only in civil cases. Property dispute, marital dispute, only in these cases. This protection is not available in case of a criminal law, or contempt of court, or preventive detention. That means a member of the parliament cannot be arrested in an ongoing session, cannot be arrested 40 days prior to the beginning of the session, 40 days after the session has expired. Why? Because legislative business, the legislative role of this member of the parliament is very important. But this is the protection available only in civil cases, but not in the criminal cases, or contempt of court cases, or the preventive detention cases. Similarly, we have freedom from jury service. That means I have witnessed a crime, or I am a witness in a property dispute or a marital dispute, right? That means I have to be present as a witness before the court of law. But the session of Indian parliament is going on. When the session of the Indian parliament is going on, I cannot be forced to perform this jury service. That means the legislative task, the role of a member of the parliament is paramount. The role is to legislate, to make laws. This is a very, very serious business. Every other role is unimportant. But the role of the parliamentarian to make laws, to legislate laws is very important, according to the constitutional experts. So if the session is going on, I have to be present in the parliament, making laws, debating the members of the parliament. I cannot be forced to perform jury service in any court of law. I cannot be forced to become a witness in a particular case if the session of the Indian parliament is carrying out. These are some of the individual and collective privileges which are available to the members of the parliament. Now, after we talked about these privileges and immunities which are available to the members of the parliament, it's high time that we codify all these parliamentary privileges and immunities. In absence of a law, there is a greater room for interpretation. And the problem is, just like this, Telangana was to be created Andhra Pradesh was to be divided into Andhra and Telangana, then there was one MP from Andhra Pradesh who entered into Lok Sabha and sprayed pepper gas in Parliament. He came to be known as Pepper Spray MP. There was some other individual who brandished his knife inside Lok Sabha. Why? Because one of the parliamentary privileges was that these members of the parliament were not frisked. They were not checked before entering into the parliament. And ultimately, what was the signal that these parliamentarians were giving to the people of this country? That look how the legislators are behaving. We look up to these politicians. We look up to these politicians. Some of these politicians also act as our role models. And it is very important that they act, they perform, and they deliver on the promises that they make to the people. And it is very, very important that they send a right signal to the people of this country. That is why we need to codify all these parliamentary privileges. Similarly, we see frequent adjournments in the parliament. Frequent adjournments. The former Speaker of Lok Sabha, Srimati Meera Kumar, she was begging the members of the parliament, please baith jaiye, baith jaiye. When no one was baith jaiye, no one was paying any attention to the words of the speaker, to the pleas of the speaker. Ultimately, she had no other option but to adjourn the house. When you adjourn the house, you are also wasting the money of the public at large. That means you are violating the exchequer of this country. Ultimately, lakhs of rupees are given to these members of the parliament by way of their business allowance, transport allowance. Ultimately, people sitting on the parliament, they're also getting money. And ultimately, the signal that these parliamentarians are sending to the people across is that they are not focused truly on their work. So what are the recommendations that we can suggest to the speaker? What she can do to prevent frequent adjournments in the house? Number one, if a member is entering into the well of the house, if the member is raising his pitch to an extent that we cannot carry on with our business, with our legislative agenda, suspend that member for the day. If the member is continuously doing this again when he comes back to the Lok Sabha, suspend him for a week. If the member is still frequently disrupting the proceedings of the house, suspend this member for the whole session. When strong action, strict action is taken by the presiding officer, only then we can ensure decorum in the house, only then we can ensure that the legislative business, legislative agenda of the house is carried out to its full maximum intent. Similarly, let's talk about GST, a landmark taxation reform in indirect taxation in this country. This was pending in the parliament for close to a decade. Why? Because parliamentarians were not in consonance. Parliamentarians were not in agreement. Sometimes BJP was in opposition. Sometimes the Congress became the opposition to the GST. Ultimately, what happened? The GST was not passed for a much, much longer time. And principal reason was that government was in minority in Rajya Sabha. So isn't Rajya Sabha then acting as a stumbling block to pass these important legislations because government is not in majority in Rajya Sabha? How can we reform it? What are the recommendations that you can suggest which can prevent such a situation? One of the reasons that Congress party and even BJP in the past stalled the passage of GST and other important legislation was they frequently disrupted the House. Disruptions took place and ultimately the legislative agenda could not be carried forward. And the reason is that frequent adjournments take place. When frequent adjournments take place, ultimately the session of the parliament is small, it gets over, and we are back to square one. What can we do, or what can we suggest to prevent the recurrence of such things? What do we suggest? Opposition agenda. What are we talking about? We are not strictly talking from the mains point of view. Parliamentary disruptions lead to disruption in the faith of the public, in the temple of Indian democracy, as well as in the laws of the public exchequer. What are the recommendations that you can suggest to prevent frequent disruption of the parliament? One of the recommendations is enforce opposition agenda. Why? And what is this opposition agenda? Congress party told the BJP that we are going to discuss GST, but first let's talk about intolerance that is there in the country. Let's talk about beef ban in this country. Let's talk about Gandhi team in this country. Ultimately, government was not acceptable to these propositions, and ultimately, what happened? Frequent adjournments took place, and the entire session of Indian Parliament was wasted. To prevent such a situation, we can recommend something. What is the recommendation? Opposition agenda. In the first session of Indian Parliament, and at the beginning of every session of Indian Parliament, we can have 3 to 4 days for this opposition agenda. That means when the session of the Indian Parliament will begin, in the first 3 to 4 days, everything that opposition wants to discuss will be discussed. Every question that opposition wants to raise will be discussed in the Parliament. There should be full-fledged debate in all these 3 to 4 days on all issues which are raised by the opposition. Why? Opposition said, let's discuss intolerance. Government said, we will not discuss intolerance. There were adjournments, disruptions. Ultimately, legislative agenda took a backseat. That means we have to do something to prevent such things. What can we do for 3 to 4 days continuously? Let opposition decide what is it that they want to discuss in the Parliament. Now, this system may not work all the time. But at least the members of the opposition will have no alibi. They'll have no excuse. They will have no excuse to say we are stalling GST because government is not accepting our demands. Now, the government will say, for 3 to 4 days, we discuss debated every issue that you raised. Now, let's come back to the GST. Let's come back to insurance. Let's come back to reforms in the labor market. Ultimately, when opposition has discussed every issue that concerns them, they will have no excuse, they will have no alibi, and ultimately, for the remaining part of that session, the legislative business, the legislative agenda will be carried forward. As I said, this may not work effectively, but at least this is a solution. This is a real solution that should be looked at into by the policymakers. Similarly, we see another issue, and that issue is not only with the Manmohan Singh government, but also sometimes with Prime Minister Narendra Modi's government, is that Prime Minister is silent. BJP accused Prime Minister Manmohan Singh of being silent all the time. He never speaks. He didn't speak on 2G scam, coal scam, Commonwealth Games scam, Argos scam, all these scams, and that is why the BJP was accusing them. Unless and until the Prime Minister speaks in the House, they will not allow the Parliament to function. Similarly, the Congress is accusing Prime Minister Modi of being silent. He was silent on intolerance, silent on Bharti killing, silent on Rohit Vimla suicide. Ultimately, what is the solution? The solution is the Britain model, which we can replicate in India as well. What can we do? For example, this is a week when the Parliament is in session. At the end of this week, let Prime Minister speak and let questions be asked to the Prime Minister. We have the provision of asking questions to ministers, but we do not have a provision where we can directly ask questions to the Prime Minister. So let's have this agenda as well. Prime Minister will not have any alibi, any excuse to remain silent on important issues because he will be mandated to speak at the end of that week and questions will be asked to the Prime Minister. It is only through this mechanism, by means of Prime Minister speaking, by means of opposition agenda, that we can have some decorum, some level of dignity in these parliamentary debates. And ultimately, what will happen? The people's trust in the parliamentarians will increase. Those people who consider these members of the parliament as their role models, they will also try and emulate these members of the parliament. This is how, one, we need to codify all these privileges which are available to the members of the parliament. Why is it that the crime is allowed in the parliament? Why is it that massive
cash was displayed in Lok Sabha when there was cash for vote scam, when Prime Minister Manmohan Singh sought vote of confidence after the left parties withdrew their support to the government on Indo-US nuclear deal. We saw massive cash was displayed in the Lok Sabha. Why is it that bribes are allowed in Parliament? Why is it that bribes are allowed which corrupt the heart and soul of our parliamentary politics? On such, we should have clear codification of the parliamentary immunities and privileges. And at the same time, to prevent these frequent disruptions, two novel solutions we have given. One solution is, let's have opposition agenda. Another solution is, let's have a provision where the Prime Minister will be mandated to speak at the end of that week. Questions will be asked to Prime Minister, and then opposition will have no excuse to say that since Prime Minister is not speaking, we will not allow Parliament to function. Now let's jump to another issue, the passage of bills. What are these bills? Bill is nothing but a set of proposals. For example, land acquisition. We want to smoothen the land acquisition process in this country. That is the objective of this bill. In this bill, we talk about if this is a land in urban area and the government wants to acquire this land, 2 times the market price of this land will be given to the owner. If the land is in rural area, 4 times the market price will be given to the owner. That means this is a bill, land acquisition bill. What is a bill? A system of proposals, a set of proposals. This bill can be introduced in either house of the parliament, Lok Sabha as well as Rajya Sabha. Because what are we talking about? We are here talking about an ordinary bill. What is an ordinary bill? A bill which is neither a money bill, nor a financial bill, nor a constitutional amendment bill. It is an ordinary bill. We have seen a provision for constitutional amendment bills when we discuss the amendment procedure and basic structure of Indian Constitution. So nothing is clear. What about this ordinary bill? This ordinary bill can be introduced in either Lok Sabha or Rajya Sabha. That means in either of the two houses. But what is this bill? This bill is a set of proposals. This bill can be broadly classified into 2 types: private members bill, government bill. What is a government bill? A government bill is a bill which is introduced in the parliament by a minister, and a private member bill is such a bill which is introduced by a non-minister. That means even if LK Advani introduces a bill in the parliament, it will be a private member's bill. Why? Because LK Advani is a member of the ruling party, but LK Advani is not a minister. A bill introduced by a minister is a government bill. A bill introduced by a non-minister is a private member's bill. So this is a broad classification of a bill. How is this bill presented in the parliament? How is this bill passed in the parliament? And what are the various provisions involved? Let's talk about that. For example, this is a bill, and we now know what is a bill. This is an ordinary bill. That means it is neither a money bill, nor a financial bill, nor a constitutional amendment bill. This bill has to pass through various stages. Number 1, stage 1, which we say first reading. For example, a member of the parliament wants to introduce a bill in the parliament. For example, Shashi Tharoor introduced a bill in the parliament where he tried to decriminalize homosexuality in this country. When he talked about that Section 377 of Indian Penal Code should be amended, which should decriminalize homosexuality in this country. Now, when he tried to introduce this bill, the permission was sought from the speaker, and normally speaker gives her permission. If the speaker does not give her permission, if the members of the parliament are objecting to the introduction of this bill, then the speaker asks for a vote. If the members of the parliament vote by simple majority, this bill can be tabled, introduced in the house. With the introduction of this bill, the member of the parliament gives a speech where he talks about what is it that he wants to achieve by tabling this bill, why this bill should be passed in the parliament, what are the objectives of this bill. After the speech is over, when this bill is tabled on the floor of the house, this bill is also published in the Gazette. That means this is the first reading of the bill. An ordinary bill has to pass through various stages. Stage number 1, what happens? The member of the parliament seeks the permission of the speaker. That means, Madam Speaker, I want to table this bill in the house. Do I have your permission? Normally, the permission is granted. If the permission is not granted, then members of the parliament vote. If they vote in favor of the introduction of this bill can be introduced. If they vote against the introduction of this bill cannot be introduced. Now let us assume the speaker gives the permission to introduce this bill, to table this bill on the house. What happens? I, as a member of parliament, have presented this before the parliament. I'm talking about various objectives of this bill. After my speech is over, this bill is tabled in the house. Together with this bill is mentioned, is noted down, and published in the government gazette. This constitutes the first reading of this bill. When the first reading is over, then we come to the next stage. Stage 2, which we say is second reading. During this stage, the bill receives not only general, but also detailed scrutiny and assumes its final stage. That means this is the most important stage in the passage of the bills. The most important stage is the second stage, where the bill assumes its final shape. How? Let's talk about that. In the second reading, what happens? The written copies of this bill are distributed to all members of the parliament. When they are distributed, ultimately discussion takes place on this bill, and there are various options which are available to the parliament. Option number 1 is that they can take up this bill immediately or on some other fixed date. That means the members of the parliament will decide, let's take this bill as a whole, let's either accept this bill or reject this bill. Or the members of the parliament can say, refer this bill to a select committee or refer this bill to a joint committee. What does that mean? Select committee. If this bill has been introduced in Lok Sabha, the select committee members would include only the members from Lok Sabha. But sometimes the parliamentarians may also feel that since this bill has to be passed by Rajya Sabha also, let us involve members from Rajya Sabha also. So Rajya Sabha members are also included in this committee, and this committee becomes joint committee of the parliament. Select committee means only members from that house in which this bill is pending. Joint committee
would mean members from both houses of the parliament, Lok Sabha as well as Rajya Sabha. And ultimately, there's a fourth option also. This bill can be uploaded to seek public opinion. Let's invite the opinion of the community as a whole. Let's see what the people of this country have to talk about, have to say, have to recommend about this particular bill. That means what are we talking about? We're talking about the passage of the bills. What is a bill? A bill is a set of proposals. An ordinary bill can be introduced in either Lok Sabha or Rajya Sabha. What happens? First stage, the first reading of the bill. I, as a member of parliament, I presented a bill before the parliament. I'm giving my speech before the parliament, saying what is the objective of this bill, what this bill talks about, why this bill should be passed by this house. After my speech is over, this bill is tabled on the floor of the house, ultimately it is published in the Gazette. Once it is published in the Gazette, we say it is the first reading of the bill. In the second reading of the bill, detailed scrutiny of this bill is taken into account. That means the printed copies are distributed to all the members of that house. Then ultimately, serious discussion takes place on this bill. When discussions are taking place, various options are also available to the house. One option is, let's take this bill in its entirety together immediately or sometime later, in the next week or next to next week, and then we will either pass this bill or reject this bill. There can be other option. One member of the parliament may get up, Madam Speaker, let's publish this bill for public opinion. Let's see the public opinion on this bill. Let's see what the larger public opinion on this particular bill is all about. Then we can incorporate those suggestions, those recommendations into this bill, or we can refer this bill to a joint committee of the parliament or select committee of the parliament. Then ultimately, this select committee or joint committee looks at this bill from all angles, discusses, debates, dissects every clause of this bill. Serious amendments can also be incorporated in this bill. And once this committee stage is over, ultimately, we enter into the third reading of this bill. This third reading is a mere formality. Why it is a mere formality? Because in the first reading, this bill was presented. In the second reading, this bill was dissected. This bill was sufficiently amended, if that was required. Ultimately, what is going to be the final shape of this bill? This final shape was given to this bill in the second reading itself. Now, the third reading is a mere formality. Whether this bill is to be accepted or rejected. That means voting takes place. Clause by clause, voting takes place, and ultimately, this bill is either accepted or rejected by the members of the parliament. This stage is a mere formality, as we talked about, and ultimately, every bill passes through all these three stages. Now, let us suppose that Lok Sabha has passed this bill by going through all these three stages, then this bill is sent to the Rajya Sabha. And then there are various options which are available to Rajya Sabha. Because we are talking about ordinary bills. What is an ordinary bill? A bill which is neither a money bill, nor a financial bill, nor a constitutional amendment bill. This is an ordinary bill. An ordinary bill goes through all these three important stages. When Lok Sabha passes this bill is sent to Rajya Sabha. What are the options available with Rajya Sabha? Rajya Sabha has first option. It may pass the bill. Pass the bill in the manner in which Lok Sabha passed this. Lok Sabha passed this ordinary bill, sent to Rajya Sabha. Rajya Sabha also passed this bill. This bill is passed by both houses of the parliament and it is sent for president's approval. The president has various options with that, and we have discussed that in the veto powers of the president. On the passage of this bill, Lok Sabha passes the bill, Rajya Sabha passes the same bill with the same content, the bill is passed. Or Rajya Sabha may reject the bill. If Rajya Sabha rejects this bill, there's a deadlock. That means we have disagreement with the kind of the bill that Lok Sabha has passed. We are rejecting this bill. There is a deadlock. Third option is it may pass the bill with amendments, with some changes. If Rajya Sabha passes this bill with some changes, this bill is then sent to Lok Sabha. If Lok Sabha accepts these changes, the bill is passed. If the Lok Sabha does not accept these changes, there's a deadlock. Fourth option, Rajya Sabha may not act on this bill for 6 months. If the Rajya Sabha not act on this bill for 6 months, there is a deadlock. So what are we talking about? This can be either way. Replace Rajya Sabha here with Lok Sabha, replace Lok Sabha here with Rajya Sabha, the procedure remains the same. For the simple argument, for the sake of simplicity, I said if a house of Lok Sabha is passing a bill, this bill is sent to Rajya Sabha. Now it can also be Rajya Sabha passes a bill, this bill is sent to Lok Sabha. If Lok Sabha passes this bill, the bill is passed. If Lok Sabha rejects this bill, there's a deadlock. If Lok Sabha does not act on this bill for 6 months, there's a deadlock. If Lok Sabha passes this bill with amendments, but these amendments are not acceptable to Rajya Sabha, there's a deadlock. And to resolve this deadlock, there is what we call joint session of Indian Parliament. Now let us talk about this unique, extraordinary feature of joint session of Indian Parliament. When there is a deadlock in the passage of the bill, the president can convene the joint session of Indian Parliament. That means this is a bill on which we have disagreements between Lok Sabha and Rajya Sabha. Now to resolve this deadlock, joint session of Indian Parliament is convened by the president. And in this case, voting will take place. That means both members from Lok Sabha as well as Rajya Sabha will be present in this joint session of Indian Parliament. Together they will vote on this bill on which we have disagreements between the two houses. And if this bill is passed by simple majority, the bill is deemed to be passed and it is sent to the president for his signature. That means to pass any bill, all the three organs of the parliament must be involved. Lok Sabha, Rajya Sabha, as well as the president of India. If Lok Sabha and Rajya Sabha disagree over a particular bill, that means there has arisen a deadlock on that particular bill. How to resolve this deadlock? The president can convene joint session of Indian Parliament. What is this joint session? Both members from Lok Sabha as well as Rajya Sabha are present in this joint session, and they vote on this bill on which we have disagreements. If this voting is passed by simple majority, the bill is passed, and it is clear that because of numerical strength of Lok Sabha, because Lok Sabha has 545 MPs, Rajya Sabha has only 245 MPs. It is because of the numerical strength of Lok Sabha that the will of the Lok Sabha prevails over Rajya Sabha. But there are two important points to mention. Point number one: who presides over this joint session of Indian Parliament? This joint session of Indian Parliament is presided over by the Speaker of Lok Sabha. Because Rajya Sabha as well as Lok Sabha is present, but significant power is available to the Speaker, and the Speaker of Lok Sabha presides over the joint session of Indian Parliament. If Lok Sabha Speaker is absent, then Deputy Speaker of Lok Sabha. If Deputy Speaker of Lok Sabha is also absent, then Deputy Chairperson of Rajya Sabha. If Deputy Chairperson of Rajya Sabha is also absent, then any member present at the joint session who is selected by the members who are present in this joint session. That means any member, as decided by those members who are present at this joint session, that member presides over the joint session of Indian Parliament. That means in no case the Vice President of India is the presiding officer of a joint session of Indian Parliament. That was one important point vis-a-vis joint session of Indian Parliament. Second important point: can we move amendments at this joint session of Indian Parliament? No, no amendments can be made, but only those amendments which resulted in the deadlock. That means, for example, Lok Sabha passes a bill, Rajya Sabha amends this bill. These amendments are not acceptable to Lok Sabha. That means because of these amendments there is a deadlock. Only these amendments can be introduced at the joint session of Indian Parliament. No other amendment. But if the bill was passed today, 6 months elapsed, the other house did not pass this bill. There's a deadlock. Joint session of Indian Parliament can be convened. But what if the situation in this country has changed in these 6 months? And that means the bill should also change because some changes have taken place in this country in the intervening period of 6 months. That means these amendments that might have become necessary due to the delay in the passage of the bill. That means, for example, today Lok Sabha passes a bill. Rajya Sabha does not act on this bill for 6 months. This bill was specifically targeted at the current situation. But the current situation has changed in these 6 months. That means those amendments which are required because of the changes that have taken place, those amendments can also be introduced at this joint session of Indian Parliament. No other amendment can be introduced. That means what are we talking about? The passage of the bills. A bill is either a private member's bill or a government bill. This bill can be introduced in Lok Sabha as well as in Rajya Sabha. For an ordinary bill, this bill must go through various stages. First reading, second reading, third reading. After the readings are over, then you transfer this bill to another house. If the house passes the bill, well and good. If the house does not pass this bill, then there is a deadlock. To resolve this deadlock, joint session of Indian Parliament is convened. But this is what we talk about in case of ordinary bills. Now this is something that we talk about in case of ordinary bills. Now let us talk about various types of the bills that we have. The first type is a money bill. Now what is a money bill? A money bill is any bill which deals with money matters. Those money matters which are part of Article 110 of Indian Constitution. That means Article 110 talks about a bill shall be deemed as a money bill if it contains only provisions dealing with any or all of these matters which are specified. That means a bill is a money bill if it deals with money matters. But any bill is a money bill if it follows only these conditions. What are these conditions? If a bill tries to impose taxes, it is a money bill because it deals with money matters. If the bill talks about alteration of a tax or regulation of a tax, it is a money bill. That means any bill which is introduced for the imposition of a tax, alteration of a tax, regulation of a tax because tax is a money matter, it is a money bill. But here one important point is to be remembered, very important. A money bill is only a money bill if the taxes are imposed by the state legislature or union parliament. If a panchayati raj body wants to impose a tax, it will not be deemed as a money bill. A money bill is a money bill if it deals with only money matters. And if it tries to impose taxes, regulates taxes, alters taxes, only if they are imposed by the union parliament or the state legislature. Taxes imposed by the panchayats do not come under money bill category. So a bill is a money bill if it tries to impose tax. Second, if you want to regulate the borrowing of money, that means the government wants to borrow money. And when it wants to borrow money, it has also to give some guarantee to that lender. That bill, which tries to provide guarantee to the lender that he will repay your amount, that bill also is a money bill. If you want to seek the custody of consolidated fund of India or contingency fund of India or the payments of money into these funds or withdrawal of the money from these funds, it is also a money bill. Now we will discuss later what is a contingency fund, what is a consolidated fund of India. But primarily here what we are talking about is that a bill is a money bill if it deals with only money matters which are mentioned under Article 110. What is this? Imposition of tax. What is it? Borrowing of money by the government of India. What is it? The custody of the consolidated fund of India or contingency fund of India. Payment of money into these funds or withdrawal of money from these funds. It is also a money bill. The appropriation of monies out of the consolidated fund of India. No money can be withdrawn from the consolidated fund of India without permission by the parliament. And that permission is what we call appropriation bill. That means if you have to appropriate money from the consolidated fund of India, that bill which tries to appropriate money from consolidated fund of India, that is also a money bill. So there are various conditions, and these are those conditions which declare a particular bill as a money bill. But the most important is the last clause. Any matter incidental to any of the matters specified above. Looks confusing, but let me simplify it. Various types of bills are there. Constitutional amendment bills that we have discussed, ordinary bills that we have discussed. There are two other important bills: money bill and financial bill. What is a money bill? A money bill is a money bill if it deals with money matters. It deals with something called money, and those money matters which are mentioned under Article 110 of Indian Constitution. What is Article 110 talking about? Article 110 talks about that any bill is a money bill if it deals with only, this word is very important, only the following provisions. What are these provisions? Imposition of tax, alteration of tax, custody of consolidated fund of India, appropriation from consolidated fund of India. All these bills are money bills. But the last clause is very important. Any other matter incidental to the matter specified above, it is also a money bill. There is also another concept here: expenditure charged. But this we will discuss after an hour when we will discuss the budget. There we will talk about what this charge expenditure is. But if any expenditure is declared as expenditure charged, that is also a money bill. It looks confusing, but I will make it even simpler. How? This is a money bill. What is a money bill? A money bill is a money bill if it deals with any of the matters mentioned under Article 110. Why is it so special? Because this bill can be introduced only in Lok Sabha. This bill cannot be introduced in Rajya Sabha. This bill can be introduced only in Lok Sabha, and that too with the previous permission from the President of India. That means a money bill is a money bill which deals with one or all of the matters mentioned in Article 110. This bill can be introduced only with the previous recommendation, with the previous permission of the President of India. And this bill can be introduced only in Lok Sabha. This bill cannot be introduced in Rajya Sabha. So when this bill is introduced first in Lok Sabha, this bill has to be voted upon. If this bill is passed by simple majority, this money bill is then sent to Rajya Sabha. Now, Rajya Sabha's role in case of a money bill is very restricted. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can also suggest recommendations. That means Rajya Sabha can merely recommend suggestions to this money bill. Rajya Sabha has no power to reject a money bill. Rajya Sabha has no power to amend a money bill. Why? That's an important question. Money, which is to be withdrawn, let's say from consolidated fund of India. Who will spend this money? The executive, the government. Government is not always a majority in Rajya Sabha. It is always a majority in Lok Sabha. If permission from both Lok Sabha and Rajya Sabha is to be sought, if Rajya Sabha will have equal role with respect to Lok Sabha vis-a-vis a money bill, it is possible that the government will be hamstrung. It is possible that government will not be provided money for its various welfare programs. The government will be squeezed of its money. Ultimately, for this reason, there is a special power which is available only with respect to Lok Sabha. That means the money bill can be introduced only with the prior recommendation of the president. It can be introduced only in Lok Sabha. When it is passed in Lok Sabha by simple majority, it is sent to Rajya Sabha. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can merely suggest recommendations, suggestions to this money bill. And if these recommendations are not acceptable to Lok Sabha, the money bill is passed. If Lok Sabha has passed a money bill, Rajya Sabha does not act on this bill for 14 days, even then the bill is passed by both houses of parliament. That means Rajya Sabha has a very, very limited role with respect to a money bill. What is a money bill? A money bill is a money bill deals with any or all of the matters mentioned under Article 110. And these are these matters. This money bill can be introduced only on the recommendation of the president, can be introduced first only in Lok Sabha. In Lok Sabha, the money bill is passed by simple majority, sent to Rajya Sabha. If Rajya Sabha does not act on this bill for 14 days, the bill is deemed to have been passed by both Lok Sabha as well as Rajya Sabha. That means Rajya Sabha has a very, very limited role with respect to a money bill. Recently, sometime back, Aadhaar Act was passed. And this Aadhaar bill was introduced by the government as a money bill. Was it a money bill or was it not a money bill? That we will discuss when we will discuss the second category of the bill dealing with financial bills. What is a financial bill? Important statement. All money bills are financial bills. But all financial bills are not money bills. Now, what is a financial bill? A financial bill is a bill which deals with some of the money matters which are mentioned under Article 110, but also something else. That means these are the provisions, if they are present in a bill, that makes it a money bill. Financial bill is also something like this. That means it will also deal with one or all of these matters. But apart from these provisions, something else will also be there. What is this something else? For example, there is a dearth of investment in public infrastructure. Roads, for example. We have very bad roads in this country, mostly full of potholes, and these roads do not survive for a larger time. Now, if we need to develop more and more roads in this country, we need investment. But private investment is dying. Private investment is not lucrative in this road sector. And what the government tries to do? Government tries to impose cess. What is a cess? Tax for a particular purpose. For example, Swachh Bharat cess. Swachh Bharat, you go to a restaurant, eat there, 0.5%, you will have to pay Swachh Bharat cess. That means the proceeds from this cess will be used only for Swachh Bharat Abhiyan. Similarly, to develop roads in this country, the government is imposing a cess. That means it's a tax. The proceeds of the cess will be deposited in a road development fund, and this road development fund will be placed under Consolidated Fund of India. For example, Consolidated Fund of India, to be very simple, is a fund available with the parliament where all the money of the nation goes. Now, what are we talking about? Money bill, we know. Financial bill is also something like a money bill. That means it contains some of the provisions which are mentioned in Article 110, but something else as well. And this financial bill, it is talked about by Article 117. What is it? Let me make it simple. The government wants to develop roads in this country. How it wants to develop it? By imposing cess, which is something to do with imposition of tax. That means it's a money bill. But what will happen? This proceeds of the cess will be deposited in a road development fund, and this road development fund will be placed under Consolidated Fund of India. Now, not just this. Who will get the contract to build these roads? What should be the past track record of that company who will develop these roads? How can we terminate the contract of those who violate the terms and conditions of the government of India? That means this bill talks about imposition of tax, yes, but at the same time it talks about something else. What is it that it is talking about? It is talking about a road development fund. It is talking about the requirements of that contract agency which will develop these roads. It is also talking about how can we terminate the contract which we have given to that organization. That means this is a financial bill. That means it deals with money matters as well as some non-money matters. Such a bill, which deals with some money matters mentioned under Article 110, but has some other matters also. Such a bill is a financial bill. Now, what will happen in case of a financial bill? This financial bill can also be tabled only in Lok Sabha. Previous permission of the president is required. When it is financial bill under Article 117 can be introduced only in Lok Sabha, that too with the previous president of the president. If Lok Sabha passes this bill by simple majority, it is sent to Rajya Sabha. Now, here Rajya Sabha has an equal role now. Rajya Sabha can reject a financial bill. Rajya Sabha can amend a financial bill. And if there's a deadlock, joint session of Indian Parliament can also be convened in case of a financial bill. A financial bill can only be introduced in Lok Sabha, and that too with the previous permission of the president of India. Now, let us look at both money bill and a financial bill again, but now in a very simple manner. What is a money bill? And what is a financial bill? A money bill is a money bill if it deals with any or all matters which are mentioned under Article 110. That means it deals with only money matters. a bill which deals with money matters mentioned under Article 110, but includes some non-money matters also, it is a financial bill. Now, what happens in this case? In case of a money bill, the role of Rajya Sabha is very limited. Rajya Sabha does not have any role in the passage of a money bill. But in case of a financial bill, only two situations are there where it resembles a money bill. It can be introduced only in Lok Sabha, and it can be introduced only with a recommendation from the President of India. Apart from that, this financial bill is just like an ordinary bill. It can also be rejected by Rajya Sabha. It can be amended by Rajya Sabha. If there is a deadlock, a joint session of Indian Parliament can be convened. But what about Aadhaar? What is Aadhaar? Primarily, we talked about that there were two important concerns. One was duplication, the other was leakage. What do we mean by that? We are a socialist state. That means benefits are to be provided to the beneficiary. What are these benefits? For example, subsidies, scholarships, kerosene, LPG, cash. But these benefits were given to the beneficiaries in such a manner that there was duplication as well as there was leakage. Rajiv Gandhi said way back in 1980s that if we send 100 rupees to the states, to the poor people in this country, not more than 1 rupee reaches the poor. What happens to the remaining 99? It is siphoned off by the middleman. That means these benefits were given to the beneficiary by a middleman. If the benefit was a pension of 1,000 rupees to a poor, this 1,000 was routed through this middleman to this beneficiary. This middleman was taking 800 out of this 1,000 rupees and giving only 200 to a beneficiary. That means there was leakage. That means despite so many socialist welfare programs, the country still remains the poor because the benefits which are given by the government to the people are not reaching the people because there is a leakage middle way. Not only leakage, there was a problem with duplication also. Beneficiaries were 100, but middleman was saying there are 1,000 beneficiaries. That means you are inflating the number of beneficiaries. Ultimately duplication, ultimately leakage. To solve this problem, his government came up with Aadhaar. What is this Aadhaar? Let's talk about this. Aadhaar is a unique identification document. That means you have seen an Aadhaar card. Aadhaar card will be provided to every resident in this country. You can be citizen of this country, you can be a foreigner, you're also entitled for an Aadhaar card. Now, in this Aadhaar card, what will happen? 12-digit unique number is associated with every member. 12-digit unique number. At the same time, biometric details are provided. What are these biometric details? Fingerprints, iris scan. Fingerprint is unique, iris scan is unique, 12-digit number is unique. That means what are we trying to do? This Aadhaar will be given to every member, which includes a beneficiary. Now, when beneficiary is provided with an Aadhaar card, that means each beneficiary will have unique characteristics, unique iris code, unique fingerprinting, unique 12-digit code. When this beneficiary is provided benefits, can there be duplication? No, because one Aadhaar for one individual, there can be no duplication. Can there be leakage? There can be leakage, but this leakage is also prevented. How is this leakage prevented? A beautiful concept called Jam Trinity. Open an account under Pradhan Mantri Jan Dhan Yojana, link it to an Aadhaar card, and link it to your mobile number. Jan Dhan for one individual unique, Aadhaar for one individual unique, mobile number may not be unique, but based on these two attributes, we can clearly eradicate duplication as well as leakage. How we can eradicate leakage? I'm a beneficiary. I have to get pension from the government of India. Now, pension will not come through middlemen. This pension will be automatically credited to my bank account. Now, the entire 1,000 rupee will be credited. 800 rupee will not be siphoned off by this middleman. Leakage is taken care of, but there was also duplication. That means the list of beneficiaries was inflated. Ultimately, when Aadhaar will be unique, Jan Dhan account will be unique, this problem of duplication is also taken care of. Leakage is taken care of. What about this mobile number? I'm an old woman in a remote corner in Rajasthan. I get some benefits from the government, such as old age pension I'm getting. When I'm getting old age pension, my bank account is located 10 kilometers away, or my post office deposit is located 10 kilometers away. I would walk 10 kilometers, go to this post office or bank account, maybe pension has my pension come or not? The bank wala or the post office wala will say, no, pension has not come yet, come back later. Ultimately, they don't have to do this. I don't have to do this. A mobile number, when I'm providing this mobile number with my pension, ultimately I'll get a message on my phone that your pension has been credited. That means this Jam Trinity will revolutionize social sector initiatives in our country. But when Aadhaar talked about these targeted deliveries of subsidies to the beneficiaries in this country, how was it a money bill? But first important point is, why was it declared as a money bill? The reason is, the government was in minority in Rajya Sabha. The opposition in Rajya Sabha was calling important pieces of legislation of the government. Ultimately, the government decided, let's table this Aadhaar bill as a money bill. Who will decide whether this bill is a money bill or not? Speaker. And her decision is final. That means if the speaker certifies that this bill is a money bill, it is a money bill, and this question cannot be inquired in any court of law. Speaker designated this bill as a money bill. It was sent to Rajya Sabha. Ultimately, when it was sent to Rajya Sabha, it had a very limited role because it was a money bill, and this Aadhaar bill was passed. But was it indeed a money bill? For that, let's look at the example. Aadhaar. What is it primarily talking about? Subsidies. Subsidies are to be targeted so that there is no leakage, so that there is no duplication. That means targeted delivery of these subsidies and benefits of the government. That means these subsidies are what? Money. That means we are talking about withdrawal of money from Consolidated Fund of India. If we are talking about money, that means it is a money bill. This is what the government said. Since we are talking about subsidies, subsidies deals with money, money matters deal with money bill under Article 110, that means this Aadhaar is a money bill. But Aadhaar did not only talk about money. It did not talk about subsidies only. It talked about biometric details, iris scan, fingerprint. It talks about unique identification authority of India, which will give these Aadhaar cards. It also talks about how these biometric details can be shared. If the court passes an order that share with us these biometric details, you will have to share these details with the court. That means it deals with money matters, yes, but it deals with some non-money matters as well. That means it should have been a financial bill and not a money bill. Because it deals with money matters, yes, but at the same time it deals with non-money matters as well. Jai Ram Ramesh, Rajya Sabha. member of parliament from the Congress party went to the Supreme Court, challenging this decision of the Speaker of Lok Sabha to declare Aadhaar as a money bill. The case is still pending. But an alternative explanation has been provided by Arun Jaitley, the Finance Minister of the Union of India. Arun Jaitley talks about that yes, Aadhaar is a money bill, and I'll tell you why is it a money bill. Why is it a money bill? Because it deals with subsidies. Yes, subsidies deal with money. Yes, money matters are mentioned in Article 110. Yes, so that means it is a money bill. Arun Jaitley was asked, but it also deals with non-money matters as well. Arun Jaitley responds, look at Article 110 and the last clause. Any matter incidental to any of the matters specified. Original intention is appropriation of money from the Consolidated Fund of India. That means we have to withdraw money from Consolidated Fund of India, and withdrawal of money from Consolidated Fund of India deals with money bill. But it also talks about any matter incidental to any of the matters specified. That means Arun Jaitley is saying original intention is withdrawal of money from Consolidated Fund of India. But incidental matter is if we have to withdraw money from Consolidated Fund of India, I have to ensure that this money is targeted accurately. For that, I should know about the identity of that beneficiary. To know about the identity of that beneficiary, I have to give him an Aadhaar card. That means this Aadhaar card, these biometric details, this fingerprint, these are the matters incidental to the appropriation of money from the Consolidated Fund of India. That means Aadhaar is a money bill. Without getting into further debate, now let's talk about briefly regarding this money bill and a financial bill. Money bill, simply any bill which deals with money matters mentioned in Article 110 is a money bill. Who will certify whether a bill is a money bill or not? Speaker. And her decision is final. And Rajya Sabha has very limited role with respect to a money bill. But when this money bill is passed by both houses of the parliament, it is sent to President. President cannot send this bill back for reconsideration. That means President cannot return a money bill for its reconsideration. President may sign this money bill. President may withhold his assent to a money bill. That means President can either give his assent to a money bill or he can withhold his assent to a money bill. Normally, President gives his assent to a money bill because of his introduction, because of his recommendation that this bill was introduced in Lok Sabha. But once it was introduced, most of the members of the government were not present in Lok Sabha. And in Lok Sabha, what happened? This money bill was significantly amended by the members of the Lok Sabha. That means the shape with which the President gave his permission to table this money bill, that shape has changed because of the amendments that took place in Lok Sabha. That means the form in which President recommended the introduction of a money bill. In the same form, the bill could not be presented to the President because amendments took place. In that case, the President can withhold his assent to a money bill. But normally, in all cases, President declares his assent to a money bill. But in case of a financial bill, they can get withdrawn in joint session of Indian Parliament can be convened. And President has all options in case of a financial bill. Absolute veto, pocket veto, suspensive veto, all these vetoes can be used by the President in case of a financial bill.
Now, we have talked about various bills which can be presented to the parliament. Ordinary bills, money bills, financial bills, constitutional amendment bills. But let me take you back to the president when we discussed the office of the President of India. We said there are various powers which are available to the President of India, but we will discuss them later. Then we talked about legislative powers. President can nominate 12 members to Rajya Sabha, that's the legislative power of the President. President can nominate 2 members from Anglo-Indian community to Lok Sabha, that is the legislative power of the President of India. President can convene the session of Indian Parliament, legislative power, can prorogue a session of the Parliament, legislative power, can dissolve the Lok Sabha, a legislative power. But perhaps the most important legislative power of the President of India is ordinance making power of the President of India. Under Article 123 of the Indian Constitution, President can promulgate an ordinance when either one or both houses of the Parliament are not in session. But what is this ordinance primarily? We discussed how a particular bill goes through various stages. First reading, second reading, third reading, debate, discussion, select committee, joint committee, consideration stage, voting stage, then it goes to Rajya Sabha, then Rajya Sabha also goes through all these various phases, various stages, then it goes to the President, and President signs this, then this bill becomes an act, and once this bill becomes an act, it is notified in the Gazette, and then this law is implemented. That means it's a very time-consuming exercise. What if there is an emergency? What if there is suddenly an outbreak of epidemic? And to counter this epidemic, we need a law. But there is no time. Why there is no time? Because Parliament is not always in session. We can't go to the Parliament every time there is an emergency, because Parliament always is not in session. There are only 3 sessions of Indian Parliament. What if during the recess of this Parliament there is an emergency? There is an urgent situation which needs our attention. That means during that emergency period, we need to first convene Lok Sabha, then convene Rajya Sabha, then table this bill in the Parliament, then the discussion will go on, voting will take place, it will be then sent to Rajya Sabha, same procedure again and again, time consuming. To prevent such a situation, when there is an emergency, and at the same time, when Parliament is not in session, what President of India can do? He can promulgate an ordinance to this effect, and this ordinance is just like any other law made by the Parliament. But the only difference between the law made by the Parliament and an ordinance promulgated by the President is that this ordinance promulgated by the President is temporary. The nature and character of this ordinance is temporary. But when we talk about emergency, please do not confuse this with President's rule or national emergency or financial emergency. Emergency can be of any kind, not necessarily national emergency or President's rule or state emergency. Any emergency, that means any development which requires our attention. But we cannot wait for the Parliament to be convened. In such cases, the President has the power to promulgate an ordinance. Now, what is this basically?
This ordinance is basically a law, but of a temporary character, which we will discuss later. But this is a law. This law is drafted by the Council of Ministers, by the respective minister. He takes the help of various bureaucrats also, and the law is framed. When this law is framed, it is then sent to the cabinet. Then cabinet clears this law. Ultimately, it is sent to the president, requesting the president, advising the president, please promulgate an ordinance to this effect. But there's only one condition. Condition is either one or both houses of the parliament should not be in session. If Lok Sabha is in session, Rajya Sabha is in session, ordinance cannot be promulgated. If Lok Sabha is in session, Rajya Sabha is not in session, ordinance can be promulgated. If neither Lok Sabha nor Rajya Sabha is in session, even then ordinance can be promulgated. That means either one or both houses of the parliament should not be in session, and the president can promulgate an ordinance to this effect. That's what condition number one. There's also another important statement here. The power of the president to promulgate an ordinance. On which subjects can he promulgate an ordinance? On all subjects on which the Indian Parliament has the power to legislate. That means what are we talking about? Ordinance. The most important legislative power available to the President of India. What is the rationale behind having this provision in the Constitution? The rationale is that if the Parliament is not in session, or only one house is in the session, that means can we pass a law which requires urgent attention of the government? No. That means in such a case, what we need to understand is that Parliament is not always in session. And at the same time, it's a very time-consuming exercise to get this law passed by the Parliament. Because we know what is the procedure. To prevent such a situation, this power is available under Article 123 to the President. But President can promulgate an ordinance only on the advice of the Council of Ministers. On which subjects can President promulgate an ordinance? On all those subjects on which the Union Parliament has the power to legislate. Because we know there are three lists. Union list, state list, concurrent list. Under Union list, the exclusive power is vested with the Parliament to legislate on these subjects. What are these subjects? Currency, insurance, external affairs, banking. On all these subjects, the Union Parliament has the power to legislate. And on all these subjects on which the Parliament has the power to legislate, which includes concurrent list, the President can promulgate an ordinance to that effect. But the important point is, if today the President has promulgated an ordinance, what is going to be the validity of this ordinance? Because I said ordinance is a temporary law. Let's have a look at that. The life of this ordinance is 6 weeks from the convening of the Parliament. That means if an ordinance is passed, is promulgated today by the President, for 3 months, the Parliament is in recess, no parliamentary session could take place. And let us assume, after 3 months, monsoon session has been convened by the President of India. From the date on which both Lok Sabha and Rajya Sabha are convened. Now let us assume for a while, both Lok Sabha and Rajya Sabha are convened on the same date. That means 12th of July 2016. The Lok Sabha and Rajya Sabha both are convened at the same time. In this case, what will happen? From the date on which both Lok Sabha and Rajya Sabha were convened, for 6 weeks after that, the ordinance will have the life of its own. The ordinance will continue to remain in operation. When the 6-week period is over, the ordinance lapses. We know the reason behind having this provision in the Constitution. We know that there is a requirement that when either one or both houses of the Parliament are not in session, President can promulgate an ordinance. And that too on all subjects on which the Union Parliament has the power to legislate. Clear? Now, what is going to be the validity of this ordinance? The validity will be 6 weeks after the reconvening of the Parliament. That means if Lok Sabha and Rajya Sabha are convened together, for about 6 weeks from now, this ordinance will continue to have the life of its own. When the 6-week period is over, ordinance lapses. Now, let us imagine another situation. Lok Sabha was convened today. Rajya Sabha was convened 1 week later. This 6-week period will be taken into account from which date? The date from which Lok Sabha convened or from the date from which Rajya Sabha convened? This 6-week period will be taken into account from the date Rajya Sabha was also convened. That means the validity of this ordinance is 6 weeks after the reconvening of the Parliament. If the validity of this ordinance is 6 weeks after the reconvening of the session, may I ask you, what is going to be the maximum validity of this ordinance? Constitution said the time frame between the first session and the second session must not be more than 6 months. So every 6 months we should have a session of Indian Parliament plus 6 weeks after the convening of the session of Indian Parliament. That means the maximum validity of this ordinance will be 6 months plus 6 weeks, which is equal to 7.5 months. That means the maximum validity of this ordinance is 7.5 months. Now let's look at other issues. If you look at the text of this Article 123, it says if the President is satisfied that either one or both houses of the Parliament are not in session, he can promulgate an ordinance to that effect. The question arose, is this the personal satisfaction of the President or is it something else? In Cooper case, 1970, Supreme Court made it absolutely clear that it is not the personal satisfaction of the President of India, but it is the satisfaction of the government. It is the satisfaction of the Council of Ministers. That means President can promulgate an ordinance only on the advice of the Council of Ministers. Similarly, case number 2, A.K. Roy versus Union of India, 1982. Supreme Court said that the ordinance making power of the President of India is subject to judicial review on the grounds of mala fide. That means if I am a petitioner, I am petitioning the Supreme Court that President has promulgated an ordinance, but I am going to challenge it because it has been promulgated on the grounds of mala fide. That means the intention of the President was very bad. That means in bad faith this ordinance was promulgated. Ultimately, Supreme Court said in A.K. Roy versus Union of India that yes, judicial review is possible. On what grounds? On the grounds of mala fide. And the Supreme Court further said that the petitioner has to prove that there existed no situation, there existed no emergency, there was absolutely no reason for the government to promulgate an ordinance. If that is proven by the petitioner to the court of law, this ordinance can be struck down by the Supreme Court. But similarly, there is another condition. I said President can promulgate an ordinance that either one or both houses of the Parliament are not in session. Now let us suppose for a while, Lok Sabha is in session, Rajya Sabha is also in session. Can President promulgate an ordinance? No. So what President can do? President can prorogue Rajya Sabha. That means President can prorogue, can terminate the session of Rajya Sabha or Lok Sabha, any of the two houses, can President prorogue or terminate the session of one of the houses of the Indian Parliament, primarily because of the fact that he wants to promulgate an ordinance? This question was looked into in A.K. Roy versus Union of India, 1982. Supreme Court said it is constitutional. That means it is constitutional for the President of India to prorogue the House of the Parliament, primarily because he wants to promulgate an ordinance. Why? Because we know ordinance making power of the President is there to deal with certain emergencies, certain contingencies. If both houses of the Parliament are present, but there is an emergency situation which has arisen, now we have to tackle the situation. Both houses are present, they are in session. President cannot promulgate an ordinance. That means we have to go through the parliamentary route to make a law on this matter. It will be time consuming. First reading, second reading, third reading, Senate committee, joint committee, so many other provisions are there. Now what President can do? He can prorogue the House of Lok Sabha or Rajya Sabha only because of the fact that he wants to promulgate an ordinance to deal with this particular case. Now we know what is the rationale behind the ordinance. Who can promulgate an ordinance? On whose advice this ordinance can be promulgated? What is the validity of this ordinance? What is the maximum validity of this ordinance? Is it subject to judicial review or not? Can you prorogue the House of the Parliament primarily because of the fact that you have to promulgate an ordinance? Yes, even that you can do. But there is an interesting case. What is the validity of this ordinance? 6 weeks from the convening of the session. Now what happens? This ordinance